Your wait time is 3 hours and 30 minutes.
It's okay, Dad. It's just not your day.
I know.
No, I mean it's not your watering day.
Oh, right.
Look!
Sometimes it's just not your day. Hillsborough County limits lawn and landscape watering to specific days in order to preserve year-round conservation. To find out your watering days, just visit hcflgov.net/water restrictions and enter your address.
Good morning, everyone. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the July 31st, 2023 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding over the majority of our cases today. With me, I'm glad to introduce also Hearing Officer Pamela Jo Hatley to my right, and she will be hearing the first case. With that, let me also introduce Colleen Marshall. She's at the end of the dais. She is with the Hillsborough County Development Services Department. She'll go over any changes we have and also introduce other members with us today. Ms. Marshall.
Good morning. We have no changes to the published agenda. To my left is Mary Dorman of the Hillsborough County Attorney's Office, and Bryce Farringer of Planning Commission staff, and joining us virtually is Carmen Mason of Development Services staff. During the course of the hearing, a number of other planners will be presenting their findings for various cases and will be introduced for each item. We have a number of continuances and withdrawals today. Item A1, Special Use 22-1563, applicant is Karina Maris O'Keek. The application has been withdrawn by the petitioner. Item A2, Special Use 22-1657, applicant is Todd Seamy. This application has been continued by staff to the August 28, 2023 Land Use Hearing Officer hearing. Item A3, Variance 23-0005, the applicant is John Grissar. The application is out of order to be heard and is being continued to the August 18, 2023 Land Use Hearing Officer hearing. Item A4, Special Use 23-0308, applicant is Gulf Stream Towers, LLC. This application is being continued by staff to the August 28, 2023 Land Use Hearing Officer hearing. Item A5, Special Use 23-0343, applicant is Five Star Cares Incorporated, care of William Holland. This application is withdrawn by the petitioner. Item A6, Variance 23-0471, applicant is Melba Mersed. This application is out of order to be heard and is being continued to the August 28, 2023 Land Use Hearing Officer hearing. Item A7, Special Use 23-0481, applicant is David Wright TSP Companies Incorporated. This application is being continued by the applicant to the August 28, 2023 Land Use Hearing Officer hearing. Item A8, Variance 23-0525, applicant is Shad Reed. This application has been withdrawn by the petitioner. Item A9, Variance 23-0560, applicant is Rue Project Management Group, LLC, Ruth Londano. This application is out of order to be heard and is being continued to the September 26, 2023 Land Use Hearing Officer hearing. Item A10, Variance 23-0590, applicant is Yenli Gerald Perello. This application application is out of order to be heard and is being continued to the August 28, 2023 Land Use Hearing Officer hearing. Item A11, variance 230594, applicant is Plato Academy, Tampa. This application is being continued by staff to the September 26, 2023 Land Use Hearing Officer hearing. This concludes the continuances and withdrawals.
Thank you, Ms. Marshall. I appreciate it. Let me start by going over our hearing procedures for today. Our hearing consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct the hearing on each agenda item and will issue a decision within 15 business days following today's hearing. Our hearing is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and I will decide all questions of procedure, rather. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation is as follows. We have two types of cases on today's agenda. We have variances, and we also have special uses. The order of presentation is the same except for how we start. For variances, the Development Services staff person presents their findings for 5 minutes. For special uses, the applicant goes first and has 15 minutes to present their cases. So back to variances. The staff goes first, the applicant goes second. The applicant then has 15 minutes also to present their case. Proponents, when we go to anyone who would like to speak in favor of an agenda item, total proponent presentation time is 15 minutes. The same is true when we go to opponents, anyone who would like to speak against an application, 15 minutes. Then we'll go back to Development Services, who has 5 minutes to address any issues that came up or any questions that are material to the case. And then finally, we go back to the applicant. The applicant has the last word with rebuttal time for 5 minutes. We do have a very full agenda today, so I will keep track of our time pretty closely for that applicant, for that testimony in favor or in opposition. If there are a number of people that want to speak, both in the room and virtually, we have people participating virtually in today's hearing as well, we'll take a show of hands. So we will count how many people want to speak, and we will divide that 15 minutes as equally as we can. If you want to have a spokesperson, that's often an efficient way to use your time. Otherwise, we will just divide it evenly. So with that, let me go to how you speak and tell you that we are recording this hearing. As you can see, we have cameras, we have video, and we are recording it for the record. There is also a court reporter. So it's very important that when you come up to speak, either if you're in the room or online, that you start by giving us your name and address. And then once you are finished, if you're in the room, if you could see Michael, he's at the end of the dais, he's with the clerk's office. He is also keeping a log of who speaks here today in the room. So if you could also sign in with your name, address, and the case number that you are speaking to. With that, let me turn to the county attorney, Ms. Dorman, who will now provide you the legal requirements for appealing a decision made by a land use hearing officer. Ms. Dorman.
Mary Dorman, County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside of the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action then is for you to write down any comments you make today and repeat them to the appeals board.
Thank you, Ms. Dorman. I appreciate it. As I mentioned, all testimony must be under oath. So if you plan to speak today, if you could please stand, raise your right hand, and I'll swear you in. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. Please be seated. All right, then with that, we're ready for the first case. I'll turn the hearing over to Hearing Officer Hatley.
All right, good morning. We'll hear from staff first, I believe. Thank you.
Today's agenda, we have no vested rights, fee waivers, or remands, which takes us to Section E, reconsideration requests. The first application is item E1, variance 22-1422. The applicant is Mike and Nicole Mesra. The request is a variance to fence requirements. Staff findings will be provided by Chris Grandleonard.
Good morning. Chris Grandleonard, Development Services. Present reconsideration variance 22-1422. The variance application was heard at the April 24th, 2023 Land Use Hearing Officer meeting. The hearing officer denied the requested variance for the fence height on May 15th. The applicant then sought a reconsideration of the matter as provided in LDC section 10.02.03.I, and the hearing officer granted the request for a rehearing of the application. The applicant is requesting a variance for an existing fence and gate on 3 commonly owned parcels zoned RDC 12. Variance per LDC section 6.07.02.c.1.a. Fences over 4 feet in height shall not be allowed within the required front yards in residential districts, except under certain circumstances that do not apply to this case. The applicant requests a 2-foot increase to the maximum permitted height to allow a 6-foot high fence and gate within the required front yards on the south side of the subject parcels along Palm River Road. Findings: the subject fence is the subject of a code enforcement case, which has been placed in the case file for this application. Per LDC section 6.07.02.a.2 and 6.04.03.f, a maximum height of 2.5 feet is permitted for fences within motorist visibility triangles at the intersections of roadways and driveways. Approval of this variance, if granted, does not obviate the need to comply with this requirement and may necessitate the redesign of or relocation of the subject fence. That concludes my staff report. I'm glad to answer any questions.
Mr. Grandleonard, I'm hearing this one. Thank you. Could you please tell me how the Land Development Code requires fence height to be measured?
Well, it's from the bottom grade of the fence.
All right. So from the ground height,
Ground
basically,
height, yes.
to the top of the fence. That's how it's measured.
Yes.
On the property where the fence is located, is that correct?
Yes.
Okay. And also, the provision, and you mentioned it in your report, about the visibility triangle, is that an issue in this case, or is that determined in some other process?
Let's see here. Well, if you look at the site plan, there's what is it? This one. Well, it's the three commonly parcels, and see here. I don't know about that.
So typically, site engineering and transportation look at the site triangle and would verify if there was any area within the site distance triangle.
And this being a fence, would there be an opportunity for staff to review that before the fence? I mean, is there a permit required in this case?
There's no permit for a fence. If there was a question, they could verify with transportation or site engineering staff.
I guess my question is in this case, at what point does that issue get reviewed?
If it was placed within a site triangle, site engineering and transportation could take a look at it and verify, but it wouldn't require a permit, so it doesn't, wouldn't typically be reviewed for that through a permit.
Would it come up as a code enforcement? Or come up?
It could. Yeah.
Okay, maybe by the end of the hearing, there could be some clarification on that.
Sure.
Thank you.
Okay.
Two more things. Sorry about that, but I have questions about this one. The 60% opaque provision. There is a provision in the code at section 6.07.02, subsection C2. And I believe that provision applies only to agricultural zoning districts, but I would ask staff to take a look at that and confirm that, please. It's under subprovision 2A, and toward the end of that provision, it says, fences in required front yard shall not be more than 60% opaque above the height of 4 feet. So is that applicable only in agricultural zoning districts?
Correct, yes.
All right. Is this property in an agricultural zoning district?
No, it isn't.
Okay. And then my last question is related to, since there are 3 lots here, and one of the lots is a flag lot. It's the one with the long, long, long driveway access.
Yes.
And not out by the road, but if you take that driveway access, at the end of that driveway access, before it opens up into the main portion of that lot, there is a gate there. Is that gate subject to the fence height requirements, or because it's set so far off, is it not part of the front yard for that lot? So do I need to consider the height of that gate in this process?
My understanding is it would have to still meet the same requirements.
Okay, because it's in the front yard of that lot, is that correct?
Yes.
Okay. That's all my questions for you then. Thank you so much.
Have a good day. Thanks.
All right, applicant, please.
Good morning. Andy Mates, 101 East Kennedy Boulevard, Suite 2800. I have been sworn. Thank you for the opportunity to present here on a rehearing reconsideration. So these parcels out off of Palmer Road are unique. They're not in a typical development area where you would have lot block. There are larger parcels that all take on unique characteristics to the individual parcel. We're here to ask you to reconsider several issues. The first is substantial fluctuations in the land grade of the subject property. I think you're well acquainted with the general location of the property, so I won't go to any pictures of that. This is generally the parcel, Palm River Road out adjacent to Adam Ower 50th Street. And as you can see, the parcels surrounding this parcel, many of those have no fencing issues or have no fences up at all. This is the area that you were just talking about as to the large entryway into the main area, and we're not aware of any non-conformity issues with regard to that gate or entrance into that gate.
And Mr. Mates, if I can stop you just a second, so make sure that we're on the same page. The gate I was asking a question about, if you put your pin right at the entrance of that flag parcel, the flag parcel right there, yeah, not too, yeah. It goes all the way back, and you can sort of see it in the tree line. You can see that gate all the way back in the back.
Correct.
And so it's my understanding then from staff that gate is subject to the height requirements as well.
And I don't believe that that gate's over 6 foot, and it's open and slatted. So as it relates to the fluctuation issues, as you can see, this is a picture taken looking, if you're at that same gate area and you look right, you can see that this fence is well below the road height. And so we believe that this is a situation that's particular to this property, to where the screening effect of the fence that would be at 6 foot as to the requested variance is, there's really not even a fence that extends 6 foot above the road height that would create the issues that I think were concerning about entry or ingress and egress to and from the parcels as it relates to Palm River Road. That road is at least several feet below the road height, and so I'm not arguing, ma'am, that the height of the fence is different, but I'm saying based upon the particular land characteristics here, that fence is well below a 6 foot height as it would relate to the actual roadway itself.
Okay, and which parcel, which of these 3 parcels is that fence in front of that you're showing a picture of?
That fence is the same fence that extends all the way down the roadway in front of all 3 parcels.
Which parcel is that picture of that you just showed me, please?
That would be 5214. This is the first adjacent parcel to the long flag.
Okay.
Okay.
All right. And from the survey that has all the topographical survey, it has contour lines on it. So it appears the road is about at 9 feet. That's the top of the bank of the slope of that swale there. It's at 9 feet. And your survey shows it goes, the lower portion of that swale is 8 feet. And then the contour lines on that first property are 7, 6, and 9. It appears there's also a swale on that property. So does that sound about right to you?
Yeah, generally, I think the contour lines are there. You can interpret from them, but in terms of as you look at this picture, when you drop down, where this fence is placed, that area is several feet below the height of the road. But I think generally, ma'am, I don't differ with your interpretation of the the survey or the contour lines.
So we'll defer to the contour lines on this survey. As far as the actual elevation?
Yes, ma'am.
Okay, thank you.
So we believe that those factors should be taken into pursuant to 6.07.02A1. And as we progress into our presentation, one of the main issues is safety out here, and so that the need to have at least an appropriate amount of screening from that roadway is a consideration that we're going to ask you to strongly consider. So secondarily, although the property does not fit within the technical definition of agricultural zoning, the property is green belted. And when you look under the exemptions, under the agricultural provisions, 6.07.00 in agricultural districts, it speaks to stables. There is a barn that is located on this parcel. The owners have horses from time to time, and the stables, again, create a unique characteristic to this property that require a fence of this height to afford the security of those animals and be sure that they don't get out onto Palm River Road.
Okay, and let me stop you there just a second, too. In my research, it appears that one of the folio numbers, and there's just 2 folio numbers, but I understand there are 3 lots. So it appears that one folio number, that would be the flag lot and the lot right in front of it, I believe those 2 appear to have an agriculture certification, but the other one does not.
That's correct.
Okay. And then the agriculture certification, of course, is not zoning.
Again, we're here on a variance. We're saying that the particular circumstances that surround this property, I'm not trying to argue that green belt equates to zoning, but when you look at the literal interpretation of the code versus the application of the code to the subject parcel, there are specific provisions that deal with stables, and we believe that those are circumstances that, taken in the totality, should afford this variance based upon the unique characteristics of this property.
And I guess the question I would have to that argument is that the literal interpretation of the code, based on the plain language of the code, that provision applies only to agricultural zoning. And this is not agricultural zoning on this parcel. So as a land use hearing officer, I guess I don't understand how the applicant would suggest to me that I could apply that provision of the code to this property when it clearly does not apply.
Well, if you look at that provision in 1, it says additionally on parcels with stables, comma, bona fide agricultural operations as defined by this code, or phosphate mining, fences up to 8 feet in height shall be allowed. So those are all in the disjunctive connected by or, and stables in and of themselves would lend to the increased height of 8 feet in those areas. And we're saying that if you look at the interpretation of the code as it relates to this parcel, and I understand that it's not specifically zoned that way, but I think it's a factor that can be taken into consideration that in the code, there are areas where parcels with stables are treated differently than other parcels. And that is an issue here in terms of the safety of those animals and the safety of drivers on that road.
Okay. I understand your argument, but I guess what the issue I have with that is that this provision is clearly under agricultural zoning districts and applicable to agricultural zoning districts. But I do understand your, I understand your suggestion of the connection, but I'm sorry I don't see the connection because this provision is not applicable to other than agricultural zoning districts.
Okay, we'd still like you to take that into consideration as indicia of treatment in the code of parcels with stables, that would apply to the unique characteristics of this parcel.
Absolutely. I will take a closer look at that. Thank you.
So this shows a gate area. This is the one entry or ingress egress area that the applicant would modify that gate to push that gate back like it is either on the flag parcel here or on this parcel, the furthest parcel away from the flag parcel. So in those areas, that gateway is abutted back a section of the fence to allow for a cleaner entry or exit from the property. And that area there, the applicant would agree to move that portion of this gate back so that there's more area there to go in and out of Palm River Road.
Okay, so then just to be clear, they are offering or proposing to configure this part of this gate the same way as it is on the other parcel, and it would push that area back a fence section. Is that correct?
That's correct. So it would be similar to this parcel.
That parcel would be similar to the other parcel, correct?
Correct.
And how long is a fence section?
I don't have the specific dimensions of one section of the fence. It appears to be fairly square from the picture, so I would assume that it's approximately 6 feet.
Okay, thank you.
We talked about the 6.07.02C1J. Within residential districts, averaging of fence heights may be allowed under special circumstances, such as with a fence located on a slope at the discretion of the county. Additionally, under 6.0701, one of the purposes of the fence code is to assure safety and security. This parcel at the corner of Adamo or 50th and Palm River Road, there's a 7-Eleven there. That 7-Eleven sits across the street from a trailer park and some other residential areas. And there's folks that kind of congregate there and hang out. And this was actually pictures just from Google Maps. These are not ones that I took at any particular time. When I pulled up Google Maps, it showed people hanging out in that 7-Eleven area. Here's another picture of that 7-Eleven with people in and out and hanging out around that parcel. Let me get the date here. On December 20th of 2022, as you can see from this criminal report affidavit in Hillsborough County, Florida, the defendant in this case parked his car in front of the subject parcels, entered into the parcel, went into the garage, and stole a car from the garage. The car was later recovered because they found keys in his car to the Triumph that was stolen. But the safety concern and the need for the ability to have sufficient screening from the roadway to the parcels. I mean, obviously the temptation arises when you can see something that you think you may want to try to go and get for yourself from the parcel. And so that ability to ensure that there is sufficient screening and that the parcels are safe from further type of criminal conduct is a significant concern and an express purpose laid out in the code and in the actual fence section under 6.0701.
And this is one of the subject properties parcels, is that correct?
Yes, ma'am. This is the flag parcel that you spoke about. So the defendant in this case went in, walked down that long, as you mentioned before, walked down to that gate, somehow got onto the parcel, walked into the parcel, went into the garage, and stole a vehicle. The other parcels that are rented by the applicant have also had issues with theft and other people entering onto the parcels. So we know that you need to make specific required findings, and we believe that the alleged hardships or practical difficulties are unique and singular, as with regards to this property, and that they are not issues that are suffered in common with other properties similarly located. As you saw from general views of the street, not all of the areas are fenced. This property has a stable due to the fluctuations in the grade and the necessity for screening and the security concerns. We believe that there is sufficient evidence within the record to find that the alleged hardships are unique to the parcel. Again, the little interpretation of the provisions of the code would deprive this applicant of rights. We mentioned the green belt, and again, I'm not trying to go back and re-argue that point, but having the green belt, having stables, having other animals that are on the parcel, they enjoy having those types of animals, puts this property more in the nature of an ag property than in the nature of your typical residential property. It's a larger parcel that affords them the opportunity to have those types of animals, and we believe that the literal interpretation would deprive them of rights. This variance will not substantially interfere with or injure the rights of others. I don't believe there's any other parcels similarly situated that have any impact. The fencing here only is in front of the parcels that are all commonly owned. So I don't believe there's any impact to any other parcels or others. As well, this variance is in harmony and serves the general intent and purpose of the code. There are a number of express exemptions allowing 6-foot fencing contemplated by the general intent of the code. Several of those are 6.07.02b, maybe up to 6 foot in height. 6.07.02c1b treats corner lots differently than other types of lots. 6.07.02c1c treats through lots differently than other types of lots. 6.07.02c1g treats fences surrounding public utility structures differently. 6.07.02c1h, as here, treats yards which abut our trailer streets or collectors differently and allowing various heights. And with the modification to that gate, I think that would ensure that there are no issues as it relates to ingress and egress from the parcels to the arterial collectors. And there's others, but the purpose of that evidence is that the code has various height requirements that are specific to use of the parcel. And here, based upon the evidence presented, we believe that the 6-foot height variance, due to safety, due to the fluctuations, due to the green belt and the animals, is very consistent with other exceptions to a 4-foot height requirement that are laid out in the code. Again, we believe that the variance would result in substantial justice being done, consider both the public benefits intended to be secured by the code and the individual hardships that would be suffered by the failure to grant the variance. So we respectfully request that you grant a rehearing, or grant the variance based upon the rehearing.
Mr. Mates, just one more thing for you, if you don't mind. The applicant submitted, again, I'm referring to that survey that has the topographical, all the information on it. And for the flag parcel, it appears that on the survey, on the south boundary of the main portion of the flag lot, not out by the road, but the main portion of the flag lot. It appears there's a 6-foot PVC fence there all the way across that southern boundary. Are you familiar with that?
Is this the survey you're referencing, ma'am?
It appears to be, although it's not in color, and the one that's in the record is in color. So yes, the southern boundary of the main portion of the flag parcel, and that would be just south of the tennis court there. And this survey shows a 6-foot PVC fence all the way across. Are you familiar with that? I just want to confirm that's there. That's what I see in the survey.
I believe that fence abuts the monastery, the monks that are to the other side.
No, not on that side. You see where the tennis court is?
Well, let me get my glasses on here.
All right, thank you.
Yeah.
Right. All right, so if you'll just move your pen down on the page, so south, yes, that boundary there. It appears all the way across that boundary, there's a 6-foot high PVC fence. At least it says so on the survey. It may be very small to see. You're conferring with your client?
I am. I
Okay.
apologize. Yeah, there is a fence there just on that one parcel.
On the flag lot?
Yes.
Okay, thank you.
Yep.
That's all the questions I have for you. Thank you very much.
Thank you, ma'am.
All right, is there anyone here or online who wishes to speak in support of this application? I do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I do not hear anyone. Back to Development Services.
I have James Ratliff of Development Services Transportation Staff is available virtually to provide some clarification regarding the site distance triangle.
Thank you very much. Good morning, Mr. Ratliff.
Good morning. Hi. For the record, James Ratliff, Development Services Transportation Review, and I have been sworn. Regarding your question from earlier in the hearing, our current processes are set up so that permits are not required to put fences in. So that means it's the applicant's responsibility or the developer's responsibility to comply with all regulations. If they didn't, of course, I would imagine there would be some personal or professional liability associated with that. And to the extent that it was brought to our attention before the fence went in, we can provide guidance on where to find those standards. To my knowledge, we don't, conduct those reviews on behalf of an applicant. That would be, their engineer or their professional's response, job to do that. But we would certainly provide guidance. And to the extent that something was put in the site triangle that we became, aware of through a code enforcement action, then obviously the property owner would be forced to remove or relocate that fence.
Okay, then just to be clear, even in a variance situation where a property owner is requesting to put a fence higher than 4 feet in the front yard of a lot, transportation doesn't review the proposal?
Correct.
And particularly where it already exists and there's a code enforcement case?
That's just a general, I guess, fact of the way our process is currently set up. I mean, that's something to the extent, because I believe the fence height typically is for a frontage. It's not necessarily speaking to a fence in a specific location. So they could move that fence and the fence would maintain the height. I mean, I guess every application can be crafted generally, but or differently rather, but my understanding is that typically, a height waiver along a frontage would be, for any fence located anywhere along that frontage, not relative to a specific fence in a specific instant. So, to the extent, I mean, certainly, I guess it would be theoretically possible for, staff to review a very specific fence in a specific location. It's just that generally these proposals don't lock an applicant into a fence in only a certain location.
Okay, Mr. Ratliff, thank you. I think you addressed the question. Thank you very much.
Thanks.
Thank you, Development Services staff, for addressing that. Anything further from Development Services?
No, thank you.
Okay, thank you. Applicant, anything further?
Thank you. Andy Mates, 101 East Kennedy, Suite 2800. The fence that was replaced had been there existing for a long period of time. It was in a very different condition than this new fence, and this was done during the COVID period in an attempt to repair and replace that fence that had been existing for 20-some years.
Yes, and I did review historical aerial photographs that are available on the property appraiser's website, and I did see that. So thank you for pointing that out.
Thank you, ma'am.
Okay. All right, this will close the hearing on variance 22-1422. And I'll turn the meeting back over to Ms. Susan.
All right, thank you so much, Ms. Howley. Then with that, let's call the next case, Ms. Marshall.
This brings us to Section F, Site Development Variance Requests. Item F1, Variance 230543. The applicant is Michael Adel Marous Aziz. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Carla Shelton-Knight.
Good morning.
Good morning. For variance 23-0543, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement. Section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on June 30th, 2023, is to allow for the placement of a shed within the 30-foot wetland conservation area setback. Per the Land Development Code, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests placement of a 12-foot by 32-foot shed within the 30-foot wetland conservation area setback. The applicant requests a 29.5-foot encroachment into the setback to allow for a remaining setback of 0.5 feet. Findings. A building permit for the shed was applied for and approved by the county on November 4th, 2022. This permit application was not forwarded to Natural Resources for review. When a hold on the certificate of occupancy for the shed was sent to Natural Resources to sign off, staff noticed the wetland setback encroachment of the shed. An email was sent to the property owner alerting him to the wetland setback encroachment and the need for this variance. And finding number 2, there is an existing fence along both sides of the yard, which is also located within the 30-foot wetland setback area, and which also requires a variance for placement in the wetland setback. The fence encroachment was not requested by the applicant, but was noticed by the reviewer during the preparation of the staff report. The fence is therefore included in the request.
Just to confirm for the record, so this has been found because the applicant applied for a permit appropriately. It just wasn't transmitted to your section for review.
Correct.
All right, thank you so much. I appreciate it. Is the applicant here? Good morning.
Good morning. What do I need to?
Name and address.
Name and address.
Yes, thank
Jessica
you.
Silver, 6803 Spencer Circle.
Thank you.
Thank you. So like the lady said, we applied for the permit, and since the permit was granted, after the permit was granted, we purchased the shed with the assumption we would be able to place it because we'd already submitted the drawings and the surveys, and those were up to code. So the permit was granted, and we purchased the shed. If the permit wasn't granted, we probably wouldn't have purchased the shed. So we were trying to go about things, in the legal manner. We have had a couple babies in the past 2 years, so we needed more storage. So we got the shed, placed it on the property. They came and did an inspection, told us we needed to add a few things, add some steps, I think in 3 locations we added steps. And then they came back and did a second inspection, and it looked like everything was good to go. So they said we need to anchor the shed to the ground. So we anchor the shed to the ground, and it's a very heavy shed, by the way. And they issued a certificate of completion that everything was up to code, everything was good to go. So we thought we were done with the whole process. And then 5 days later is when we received the email, like, no, everything's not okay now. You either have to apply for a variance or move the shed back 30 feet or remove the shed. So we just purchased the shed, so we don't want to remove the shed because, we got the permit, we got the certificate of completion, and now, move this big heavy shed that we just purchased. So that was not a good option. And moving the shed back 30 feet, we don't have room to move the shed back 30 feet on the property. So that's not really a viable option for us either. So the variance, that's when they said we could apply for the variance, and we decided to, which is why we're here now. Anything else you want to add?
Regarding the...
Give us your name and address also.
Mike Ladder, Mahrous Aziz, 6803 Spencer Circle, Tampa, Florida.
Thank you.
Regarding the fence, it's actually, when we bought the house, it was there, and it doesn't belong to us, it belongs to the neighbors. Even you see that we have the column, and they cover it from their end.
So it's not on your property, is what you're saying?
Between me and them,
It's on the line?
I'm not 100% sure, but...
But just for the record, the staff report says you don't want to add that to this process, the fence issue. You just want to deal with the shed.
Yeah, I don't care about the fence. It's just mainly the shed that we installed, and we get the certificate of completion, we've done the permit, we've done everything as legal as we can. And then we end up now not know what to do with it.
Understood.
Yeah, and maybe if we know from the beginning, we consider like a smaller shed or no shed. But now it's like we invested, we put it. Moving it out is not that easy. We need it. So we're in that situation now.
I understand. Yeah. All right. Thank you so much. Is that your presentation? Yeah. The end of your presentation? Thank you. I appreciate it. If you could both please sign in with the clerk's office. All right. We'll ask for anyone who would like to speak in support, either here in the room or online. Is there anyone that would like to testify in support? Seeing no one, is there anyone in opposition to this request? No one. Development Services, anything else?
No, thank you.
All right. And you all have the last word, but you don't have to take it. You're good? Okay. All right. Thank you. Then with that, we'll close variance 23-0543 and go to the next case.
Next case is item F2, variance 23-0589. The applicant is Eddie Suarez. The request is a variance to encroach into the wetland setback to include a septic drain field. Staff findings will be provided by Carla Shelton Knight.
Good morning again.
Morning again. For variance 23-0589, the applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on November 3rd, 2021, is to allow for placement of a septic drain field within the 30-foot wetland conservation area setback. Per the Land Development Code, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the placement of a septic drain field within the 30-foot wetland conservation area setback. Variance 21-1230 was previously granted to allow the construction of a single-family home and retaining wall within the wetland setback, but that request did not include the construction of a septic drain field. The applicant now requests a 13.8-foot encroachment into the wetland setback to allow for a remaining setback of 16.2 feet for the septic drain field. Findings. Per the comment sheet from the Environmental Protection Commission, for the original variance, the retaining wall installation is not authorized to be placed in the wetland. Finding number 2, a wetland setback compensation planting plan has been provided on the site plan dated November 3rd, 2021, that provides equivalent square footage of compensation planting to the amount of encroachment.
All right, thank you so much. I appreciate it. Is the applicant here? Oh, I understand the applicant's online.
Yes.
All right, I don't see you yet.
Hello? Go
Good morning.
Sir. Hello, good morning. My name is Eddie Suarez, 5892 Hendricks Lane, Middleton, Georgia. Yeah, so basically, we're doing this process on our own for a residential property for us to live on, so pardon my ignorance. Yeah, we did the variance before, and I wasn't aware I needed to include the septic drain field to the variance, so that's why we're doing this revision. And just to tell you a little bit about the system, it has been approved by the health department. It is an engineered system, so once the waste gets treated through the septic system, it's going to come out as clean water. Yeah, so that we believe won't affect the wetland area, if any, because they say it's supposed to be drinkable water. I don't know. So yeah, that's pretty much it as far as what I have to say.
Mr. Suarez, one question, and that is, did you analyze if it was possible to put the drain field adjacent to the house or in an area that's not in the wetland setback?
Yes, we did. The property is, I believe, 0.47 acres. It's a decent sized property, but most of it is wetland. There's only a small portion that we can use, that's the upper land that we can build the property on. The house itself is only 800 some odd square feet. So yes, there's only a small area where we can build and where we can also place that septic drain field. And that's why we had to go with an engineered system, which is more costly because it's, it's just, there's not much place we could put it. We put it as far away from the wetland in the corner, and we got the engineered system, which is more costly, but that's just what we had to do to be able to get the approval from the health department.
All right, thank you. That's my only question. I appreciate it. All right, we'll go to anyone that would like to speak in support. Anyone either in the room or online that would like to testify in support. Seeing no one, anyone in opposition to this request?
I believe we do have one person online.
Okay.
Sandra Bermudez is signed up in opposition. Sandra, if you're there, you can unmute yourself.
Yes, I'd like to retrieve my opposition. I have no issues with this request.
All right, thank you for that. I appreciate it. Anyone else that would like to testify in opposition? All right, seeing no one, Development Services, anything else?
No, thank you.
All right, Mr. Suarez, you have the last word if you'd like it.
I'm good.
Okay, thank you so much. Then we'll close.
Madam Hearing Officer, I need the person that spoke in opposition that rescinded their opposition to ID themselves and give their address.
All right, Ms. Bermudez, if you could give us your name and address just for the record.
Yes, ma'am. Sandra Bermudez. My address is 6405 North Gomez Avenue, Tampa, Florida, 33614.
Perfect. Thank you for that. I appreciate it. So then with that, we'll close variance 23-0589 and go to the next case.
The next item is item F3, variance 230592. The applicant is VDL Lots LLC. The request is a variance to encroach into the wetland setback. Staff findings will be provided by Carla Shelton Knight.
Good morning.
It's 23-0592. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on June 6, 2023, is to allow for the construction of a portion of 4 villa units within the 30-foot wetland conservation area setback. Per the Land Development Code, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot conservation area setback. The applicant requests the construction of 4 villa units within the 30-foot wetland conservation area setback. The applicant requests encroachments of the following distances into the setback. Lot 7, a 6.8-foot encroachment with 23.2 feet remaining wetland setback. Lot 8, a 15.6-foot encroachment with a 14.4-foot remaining wetland setback. Lot 9, a 13.7-foot encroachment with 16.3 feet remaining wetland setback. And Lot 10, a 13.1-foot encroachment with 16.9-foot remaining wetland setback. The findings, per the applicant's narrative, a wetland setback enhancement plan that provides nuisance and exotic species removal and compensation planting within the remaining wetland setback will be provided. The enhancement plan must be provided for each unit when applying for building permits. Finding number 2, per the applicant's narrative, the remaining enhanced wetland setback will be placed in a conservation easement to be maintained by the homeowners association. The conservation easement must be recorded with the clerk's office prior to the approval of building permits for each unit. And number 3, a retaining wall located within the wetland setback area on lots 7 through 10 was previously approved on the subdivision construction grading plan. This retaining wall was approved administratively and does not require a variance for construction.
Ms. Shelton, we can ask the applicant if it's appropriate, but I just wanted to clarify the amount of the variances because the encroachment and remaining setbacks that are cited in the staff report are different than the applicant's narrative that's in my backup for this item. And so has that just been clarified that the staff report is now correct?
I based the distances for the encroachments from the site plans.
Okay, and so those are your numbers that are in the staff report?
Correct.
Okay, all right, then we'll ask the applicant to clarify that.
Okay.
Thank you so much. Is the applicant here?
Good morning, Madam Hearing Officer.
Good morning.
Joe Moretta, Gardner Brewer, Hudson. Myself and Roseanne Clementi will be teaming on this presentation. I'll speak to the orientation of the site relative to the criteria, and then Roseanne's going to speak to the status of the wetland setback area, the enhancement plan, and also the conservation easement. I know that we have 15 minutes. We may take a little bit longer than that, but I'll try to not duplicate what Carla just mentioned. The total encroachment area for the 4 lots is 926 square feet or 0.02 acres. I would defer to the site plan acreage on that, however, which is the most accurate figure. I believe that figure may have been adjusted.
So, Mr. Moretta, would you see my question, the staff report, the encroachment and the remaining setbacks, the figures that are listed are different than in your narrative, which was dated May 24th of this year.
The larger figure is the one that would apply.
The
larger encroachment, the expanded encroachment is the one that would apply.
Well, then that is wholly different than, because your encroachment in your May 24th letter, just take lot 7, for example, and we won't count this, Michael, towards his time. This is my question. Lot 7, you cite the encroachment is 18.7, oh, I'm sorry, you're right. You're right, I'm reading it backwards. So her encroachment for Lot 7 is 23.2, and you had 18.79. So her numbers would be larger.
Yes.
And so you
There
would
was a
defer to
survey submitted after the initial submittal, which further clarified the encroachment area.
Okay.
So that's why I'm saying I would go with the data that has the greater encroachment.
Okay, perfect. All right, thank you so much. Go ahead.
As you know, the project is generally located in Lutz, east of North Florida Avenue and west of Nebraska Avenue. The development product will be townhomes. There'll be one building, 2 dwelling units on 2 lots. So changing of one building would affect really both units. The site is depicted on the aerial. The green dot depicts the area. Ellen Lake is located to the south. These lots are oriented to the northwest of Ellen Lake. More specifically, the lots are nestled between ongoing and existing development. The site, again, is on the northwest side of the lake, depicted in this aerial. On both sides of the area, which is the subject of this application, there's ongoing construction, and there's an existing road with infrastructure to the north. Excuse me. The plat was intended to accommodate a townhome product, as noted, 2 attached homes utilizing 2 lots, which are 3-bedroom, 2-bathroom dwelling units. The townhomes were designed to utilize a 3,500 square foot lot. The lot size really leaves little room for adjustment, even without any type of constraints. In this situation, we do have constraints. The lots are constrained by the wetland, and the wetland setback to a point where they cannot be used for the anticipated building square footage for which they were engineered to accommodate. The 2 home designs are the only home designs being used in the development. They're not able to revise these home designs without eliminating the functionality. They've been honed down pretty much to be very efficient and utilize a small lot design. The construction was significantly delayed because of the pandemic. The identification of the constrained building layout for lots 7 through 10 did not become apparent to early this year, and did not become apparent to early this year after all the infrastructure, other homes. There's homes on the plat which have, they're already people living in the homes, the infrastructure's in, so it's a very difficult circumstance for the applicant. An adjustment to this point to the plat is simply not feasible. Again, I'm going backwards on the PowerPoint. The lots are irregularly shaped on the shoreline of Ellen Lake. The wetland and corresponding wetland setback, we believe, is unique and singular with respect to the subject lots. The wetland, the corresponding wetland setback, departs from a consistent pattern on this lake and extends much deeper into the lot area when compared to adjacent lots, which are similarly situated. These subject lots are the only lots, I would point that out, they're the only lots in this area of the plat which include an actual wetland which occupies the rear of the lot. This poses many different problems. As you can see by the plat, the yellow area to the north and south of the subject site depicts the actual wetland area setback. The red area actually depicts the wetland on the lots themselves, protruding to the northwest, and then the corresponding setback, which takes nearly almost up to half the lot in some cases, which extends from the wetland. So there's a significant constraint on all of these lots. These lots include a wetland and a setback, which in no way are similar. They're very unique. They're no way similar to any other lots in this development. The literal interpretation and provisions of the code would provide the applicant of rights commonly enjoyed by other properties in this development. All the other lots in the plat are utilizing the proposed designs, which are the subject of this variance. So every other lot has one of these 2 designs that are proposed to be on these lots. The subject lots are compact and constrained by the wetland with the lot corresponding setback, as I said, to a point where they cannot be used for the home product. They were intended to be accommodated by the engineer of record, and they're used in all other areas of the plat. The plat and associated plans are designed for a compact, efficient use, and the home design will be dysfunctional, as I noted before, if it's changed. The plot plan depicts where, in the green, where this wetland setback area resides on the lots and how it relates to the building, which will accommodate both units. This is lot 7 and lot 8. This is lot 9 and Lot 10. So as you can see, there's a significant amount of encroachment area or relief that's needed to allow this home product to fit on this lot being driven by the wetland. The variance would not injure or interfere with the rights of others. By contrast, approving the variance would maintain a consistent development product and a pattern of development that's the same development type and size as all the existing development in the plat. This aerial depicts the existing development in the plat. These homes all have people living in them to the north. Some of them are still in a state of being marketed for sale. There's ongoing construction going on to the east and west of the subject site. But every one of these homes, every one of these rooftops in this picture are one of these two development products. So we believe that the variance would allow these lot owners to have the same product, the same opportunities by the zoning as anyone else in this plat. The variance will be in harmony with the comprehensive plan, as the variance will allow the implementation of the comprehensive plan to be completed for the development type that was approved in the plan development zoning. So we believe this would continue to implement the comp plan. It's totally consistent with it. It will allow consistent and compatible development in this area. I'm sure you're aware of the zoning standards. I'll skip over this slide. This just indicates what the setbacks are, the lot size, and the number of stories. The variance does not result from a legal act. The property owners have complied with all the applicable regulations and requirements. The hardship was not self-imposed. It was not self-imposed by the property owner. It was not self-imposed by the engineer of record. It was just something that was an oversight when the plat was being prepared on these small lots. The property owner is seeking the appropriate process to be considered for relief. The property owner was not aware the plat was designed with the law constraints that would facilitate the product, that would not facilitate the product they requested to be engineered for. The property owner became aware of the law constraints after the building plot plans were ordered, and all the other areas of the site were constructed for the most part, including the infrastructure. Approving the variance will result in substantial justice being done. The construction of the subdivision is nearing completion, including existing roads, infrastructure, and occupied homes. A replat and redesign, it's simply not feasible. If relief is not provided, this will be a significant hardship for the property owner. The variance would provide the appropriate relief for the property owner to utilize the plat for the product it was engineered for, while protecting the setback areas with other measures to be discussed. Roseanne's going to speak to a setback enhancement plan, conservation area that is conservation easements that's proposed for the remaining setback area, and also to the status of the existing wetland setback area. Before you is a plan now up on the overhead that depicts the lot grading plan with the wall that's actually located further into the setback area than where the footprints of the homes are. Roseanne is going to speak to that piece and speak to the benefits of what we believe our plan would provide. Thank you. Thank you, Roseanne.
Thank you. Ms. Clementi, just so you know, there's about 6.5 minutes
Okay.
left.
Roseanne Clementi, Clementi Environmental Consulting, 620 East Twig Street, Tampa, Florida, 33602, Suite 206. As you can see, the wall was permitted to be put in because of the change in elevation in the back of these lots. This lake, this is called Ellen Lake, and does not have a natural shoreline as most Central Florida lakes do. There's a high top of bank on this west side of the lake, and at the particular lots we're asking for the variance, erosion had occurred over the years, and so the boundary of the lake cut in to those two lots. So going to EPC to fill it wasn't an option. So our plan is to remove this retaining wall from the site plan, from the construction, and then the two buildings, which house 4 units, will be built with stem walls so that there will be no fill beyond that wall. And this shows the extent of the encroachment in the setback versus most of the 30-foot setback. Our plan is to go in and remove all the nuisance species I think it's about 0.42 acres of setback. Right now, it's riddled with Brazilian pepper and melaleuca trees, Kogon grass. So our plan is to go in and remove all those species, and then we will replant with native shrubs and grasses. So it's 926 square feet of encroachment setback, which is 0.02 acres, and the rest of the setback was like 0.42. If this variance isn't, if we don't get this variance, the lake will suffer, the setback will suffer this the area won't be restored. The setback now is really not in a natural condition. This is behind slots 7 and 8. This is looking from 7 and 8 towards 9 and 10, and this is a little bit further north on the setback where it's full of Kogon grass. So right here shows our enhancement and replanting plan, which goes the whole length of the shoreline owned by this development. As you go south, the 30-foot setback's a little smaller because they were able to put a stormwater pond in there. So there's no deception here. It just is a little smaller to the south, but we've got the square footage in there. They will, after completing, or even now, implement a conservation easement, have a surveyor write a conservation easement for the entire setback that's left. And that easement will then go to the ownership or the purview of the HOA. And then we will come up with a maintenance and monitoring plan. So with the conservation easement will have to be written such that it allows the HOA to maintain it in its natural state. The other provision that the applicant is willing to do is that all of the finished products have little screen porches and exit to the rear. They're going to eliminate those exits to the rear on these 2 buildings or these 4 lots. They'll have a screen little porch, but they will not have a door that allows them to go into the back. Reducing this impact, the setback will not really have any direct or indirect impacts to Ellen Lake. It includes, again, the conservation easement, the enhancement, the removal of nuisance species on the entire setback, and the applicant, the HOA, will then be responsible to keep it in the state that we put it in.
Let me ask you a question. If you can go back, if you have a graphic that can show me that, maybe it's this one, the location of the conservation easement relative to the building. Is that what I'm looking at? The
Yes,
red?
all of that will go into the conservation easement. So there's a.
It's a broader area.
I can't zoom in for you, sorry, but.
Oh, it's okay. That's
yeah.
all right. I have these graphics in the backup,
Yeah.
I believe.
Yes.
But I just wanted to clarify for the record. So, and if it's you, good. If it's Mr. Moretta, that's fine. But my question is, and perhaps even to staff, the limitation of the rear access as a condition that you're proposing. You said it's a screened porch.
It's really a screen, it's not very big. It's about the width of the doorway. So they have a little vestibule or screen porch so people can exit and go back the back of the units. All the other units have like a 4 or 5 foot strip of grass for them to be able to go behind the units. Now, no one will ever stop anybody from walking in the setback, which is appropriate. It should be allowed. But then the HOA will be the police officer to make sure they don't put their barbecue grills back there or any other, household objects or swings or things like that.
All right. And so, Ms. Marshall, maybe we can come back to this question, or if you know now. I just wondered from a building permitting perspective about limiting access to the rear of a structure. Now, Ms. Clementi's testimony is that this is a screened area, so perhaps not the physical building, but to my knowledge, that has not been done, and especially in terms of a variance as a condition, that is a building permit, perhaps a fire code issue. And so I would need some guidance about that, whether that is appropriate. And if
We
you have any
did seek
information-
guidance. Yes, we did seek guidance. There are 2 ways to exit the units. The fire code is that they have to be able to exit the units in 2 different places or areas. They have a front door, and they can also exit through the garage. So we were told that this would not violate the fire marshal codes.
All right. I think that's the end of my questions for the
Okay.
applicant. Thank you for that. I appreciate it. Ms. Moretti, you have 2 minutes left.
I just wanted to note out that the conservation area that Ms. Clementi is pointing out is much broader than just for the 4 lots. So by way of this application, there'll be broader protections all the way along that setback area. The other thing is I have a copy of the grading plan. Staff asked that we provide that in the record. I have a copy of the presentation, which includes the graphics, just in case you don't have them. I can submit this copy to you, and I have one for the clerk as well. And we are available if you have questions.
So one final, and thank you for submitting all of those into the record. So back to my question about the limitation on the rear access of the structure. So that would be recorded as a part of the homeowner documents? How would that be memorialized?
The builder indicated to us that they had no intention of providing direct access to the back of the property. I believe it's not something that, you know, is a significant contributor to this case. I believe the main thing is that the wetland area needs some attention. The setback area needs some attention. We're going to clean that up. We're going to provide a conservation easement to make sure that after all that's done, that, you know, people aren't putting swing sets or barbecue pits in there. And, you know, in addition to that, the area is going to be much broader than just for the 4 lots. I think that's the main thrust. You know, in addition to meeting the criteria, you know, I believe there's a strong case for it, meeting the 6 criteria, even without the add-on of the conservation easement, et cetera. But I believe in total, this provides a very strong plan to come up with something better than what even the code would require. So on balance, we believe at the end of the day, we've met the intent of the code by providing, you know, greater protections in perpetuity, which the code simply doesn't provide. So we have a cleanup, we have a maintenance plan, we have a plan that goes broad on these 4 lots. You know, if the setback, excuse me, if the screen porch enclosure is an issue, my suggestion would be if it needs to be a condition, then it could be written in a way that unless, it is in conflict with fire codes. And obviously, we wouldn't be looking for a variance to a fire code. So, but again, I don't believe that's the main thrust of our case. I believe that's something that was discussed at the first part, but as this evolved, as a conservation concept, you know, entered into the discussion, I believe that we're confident that that is the best plan for this. So.
All right, understood. Thank you for that information. I appreciate it.
I do have these. I can give you a copy, and I'll pass a copy to the clerk
You
as well.
can just submit everything to the clerk, and then
Okay,
I see it.
thank you.
That would be perfect. Thank you very much. And if you could both sign in if you haven't already. All right, then we'll go to anyone who would like to speak in support. Anyone in favor of this application? Seeing no one, anyone in opposition that would like to speak? All right. Development Services, Ms. Marshall.
Nothing further.
All right. Do you have anything to add regarding, my concern about the limitation on access to a structure is what, in my view, is outside the purview of this variance because of the building code fire safety issues. I certainly understand the proposal and the reason for it, and they're trying to protect that setback area. I think it moves in the right direction. I certainly don't understand that. But I don't want to create an issue. Perhaps, Ms. Dorman, you have something you'd like to add?
I am happy to answer any question that you have. I understand your comment, and I share your concern.
Okay.
So.
All right. Thank you for that. Anything before I move on? All right. Mr. Moretta, you have 5 minutes for a rebuttal.
Madam Hearing Officer, we can remove that from the request if that causes an issue. You know, I believe it would add some layer of protection, but obviously there's still going to be access to that area. This would only eliminate direct access. So there would still be access from other areas at home. But if that poses an issue, we can just simply eliminate that from the request.
I appreciate that. And I do think that the commitment to making it a conservation easement provides that protection. So I think eliminating the restrictions on, and if you wanted to do that through the building department, through that building permit process, fine.
Thank you.
I just think that removing it from this conversation is probably the best course.
We would agree to that, and thank you very much.
All right.
Appreciate that.
Thank you.
And thank you for your time.
All right. Then with that, we'll close variance 23-0592 and go to the next case.
This takes us to section G, sign variance requests. Item G1, variance 23-454. The request is a sign variance. Staff findings will be provided by CM Ball.
Good morning.
Good morning. Sam Ball with Development Services. The applicant is requesting a sign variance from LDC Section 730C1B to accommodate a residential entry sign. LDC Section 730C1B requires that all ground signs shall be set back a minimum of 10 feet from any side yard property line. The applicant is requesting a 7.5-foot decrease to the minimum setback required, which would allow a 2.5 setback from the adjoining property located west of the entrance to the Aspen Heights multifamily development. That concludes my report. I'm available for any questions.
No questions at this time, but thank you. Is the applicant here?
Yes.
Good morning.
Good morning. Aaron Lake, 8815 Conroy Windermere Road, representing Citrus Sign and Installation. So does that show up? Okay. So this setback, we're requesting the hard, I just lost my train of thought.
It happens.
The variance we're requesting, so this side of the property of this entrance, this is the only entrance to this multifamily project. It's a very odd assemblage of how the layout is, and this is the only entryway. And this property is a wetland, so getting any kind of variance, I feel like, for setback of a sign on this would be probably near impossible. This other development is, right now it's a retention pond. I don't see it ever being developed as it is and it sits right now. So this seemed like the very logical place to be able to put the overall monument sign for this residential development. And our request is really just, we need something that shows some sort of identification for the neighborhood, just for emergency services and so forth, just because this is not a very public road, if that makes sense. So this was the most appropriate place to put the monument.
All right. Thank you very much. I understand. If you could please sign in with the clerk's office if that completes your presentation. Thank you. All right. Is there anyone who would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, thank you.
All right. Thank you. Sir, you have the last word if you'd like it.
No, there's
All right. No questions. Thank you for that. Then we'll close variance 23-0454. Go to the next case.
This moves us to section H, variance request. Item H1, variance 23-378. The applicant is Jose H. Ramirez. The request is a variance to lot development standards. Staff findings will be provided by Tanya Chapello.
Good morning.
Good morning, Tanya Chapella, Development Services staff. The applicant is requesting a variance to lot width requirements. This variance is related to a parcel subdivision for an existing parcel, zone AS-0.4. Per the Land Development Code, section 6.01.01, the required minimum lot width for property zone AS-0.4 is 150 feet. The applicant requests a 33.89-foot reduction to the required front yard setback to allow a lot width of 116.11 feet. According to the Hillsborough County Property Appraiser records, the lot was created in 1996 after the zoning conformance date and cannot be deemed as legally non-conforming. There is no record of a subdivision approval for the subject property. Subdivision review and approval through the Development Services Department shall be required following any variance approval. And this concludes my presentation.
All right. Thank you so much. I appreciate it. Is the applicant here? Is the applicant here for variance, excuse me, 23-0378? Good morning.
Good morning. Virginia Bryant, 5510 Gator Country Drive. My property is one property over from the subject property. I don't understand the terminology subdivision. There is no subdivision out there.
Ma'am, let me ask you, are you the applicant for this property?
No, I'm sorry. I thought you were asking for opposition.
Not yet. Hold that
Okay,
thought.
my
Yes,
bad.
we were looking for the applicant, but stay close in that front row.
I have tinnitus, so it's hard
Oh,
to hear you.
Not a problem. I apologize. Just stay in the front row, and we'll get back to you in just a moment. Is the applicant here for this variance case? Do we have any information?
Do not, we can try to call them and move it.
Okay, so
later.
what we're going to do, ma'am, is we're going to continue this, and because we don't have the applicant. The applicant has to testify. So we're going to put this case on hold. So if you just sit tight for a minute, they're going to try to contact them, and I'll get back to you on that. All right, so Ms. Marshall, let's have Ms. Mason try to contact the applicant if she's available, and we'll move on. We'll just put this case on hold and move on to the next case.
Sure. So the next case is item H2, variance 230462. The applicant is Donald C. Wolfert and Patty J. Isaacs. The request is a variance to minimum lot size by available utilities. I'll be presenting the staff findings. The applicant is requesting a variance to accommodate a parcel reconfiguration on property zoned RSB. Per LDC section 60106(3), a minimum lot size of 1/2 acre of upland is required for the use of a septic system. The applicant is requesting a 0.16 acre reduction to the required upland for folio 50641.0050 to allow 0.34 acre of upland, and the applicant's requesting a 0.12 acre reduction to the required upland for folio 50641.0030 to allow 0.38 acre of upland. I have an exhibit up on the projector, if we can get that up. Okay. Just to kind of clarify what's happening, so the where you see the purple is showing the current northern lot and then the lot to the south. And the red and yellow are showing the proposed lot lines approximately. And so it's the lot line of the southern folio will be shifting north to accommodate the required setback for the mobile home that's on the property. When it was placed on the property originally, the plans showed a 10-foot setback, but it was placed just over the property line slightly. Okay. And I'm happy to answer any questions.
No, I think you explained it perfectly, so thank you for that. All right, is the applicant here?
Yes, sir.
Good morning.
Good morning. My name is Donald C. Wolfer. I live at 11209 Englewood Drive, and I'm here on behalf of my property next door, 11217 Englewood Drive. To be perfectly honest, I don't even know why we're here under Article 6, because if anything, the property was already in compliance, and it was done before 1989. It was established in the 60s. And the problem appeared in 2010 after the homeowner had a brand-new home purchased and set on the lot, and the inspector signed off on it where it was not supposed to be. That created the problem. Under the guidelines, it should be under Article 11, Section 1103.03, and under the Section 1103.04, where unconforming home to lot to home structure. That is really what it should be here for today. But under Article 6, like I say, my property was already established, and I've brought proof to show that people across the street in my same area, under the same exact zoning, just in the last 2 years, put new septic systems on their properties. And Pretty much, that's the problem.
Let me back up just to make sure I understand what you're saying. So you own the subject property, correct?
Yes, ma'am.
And you're trying to subdivide it to get 2 lots, is that right?
No, ma'am.
Oh,
It's already 2 lots.
It's already
I've
2
been
lots.
paying taxes on it for years. The problem is under 307, you're allowed to, if a dwelling is deteriorating or condemnable, you can replace it. And in 2010, the gentleman replaced the home with a brand-new manufactured home. And that took it into, that made it a code violation with, under the Article 3 of RSB, with a home sitting over the property line, number 1, because you're not allowed to have more than 1 home on a lot. And number 2, it made it another stipulation in the same article where it's not 10 feet away from the property line. So now I have a problem. I can't sell my properties because I don't have a clear deed.
so do you live on the property to the north? Is
Yes,
that correct?
ma'am.
Okay, now I understand. All right, so you own also that property to the south, and someone other than you got a building permit for that new mobile home and put it
No.
over the line?
Another gentleman owned it at the time.
I see.
In 2010, he purchased a brand-new home, or he purchased that home, and he was out of town because he was a Carnival, RSB. It was in March. He had to go out on the road. And when he did it, he had a permitting company and the manufactured company apply for the permits and everything on his behalf. And it should be in public record under the permits themselves.
And then placed it over the property line?
When the trailer was set, the inspector didn't do his job, straight up. I mean, it's simple as that. He should have never signed off on it as a project, knowing that, number 1, he was turning around and violating 2 codes all by itself. Before the home was set, the property was in compliance.
And did you buy the southern lot from him?
The gentleman passed away, and I turned around and we purchased it because we were going to stay there and rent it. But now, because of my disabilities and stuff, things are getting harder. Materials are costing more, and my check is not getting any bigger. We'd like to move back north to be with our families, our children.
All right, thank you. I know that was painful to go through, but I need to understand the detail of it.
I understand,
so
ma'am.
Thank you, I appreciate that.
I really do appreciate your time today.
All right, so I do understand your request, and unless you have anything to add, we'll move on.
Nope, well, yes, I do. I beg you guys to help me out.
All right, thank you for your time and testimony. If you could please sign in with the clerk's office.
Would you sign
Really
it for me?
appreciate it. All right, is there anyone that would like to speak in support? Anyone in favor of this request? Seeing no one, anyone in opposition? All right, Development Services, anything else?
Just one quick clarification. So the 2 folios as they're currently existing are legal non-conforming to that requirement, and the reconfiguration is what then essentially requires conformance with the code, which is then why the variance would be needed.
I see.
To allow for that.
All right, thank you so much. Sir, you have the last word if you'd like it, but you don't have to take it. If you do, you have to be back on the microphone.
I would just like to say to make both of these properties, I know under Article 11.3, with conforming to them, you could actually put the 2 properties together, but to make it a lesser code violation. But in all actuality, it would make a bigger code violation because you're not supposed to have more than 1 septic per lot.
Understood.
Thank
All right,
you.
thank you for that, I appreciate it. Then we'll close variance 23-0462. Do we have any information? Ms. Marshall, do we have any information on the applicant that was missing?
We do. He has indicated he's working and cannot make it, but he has asked to proceed without presentation, but we're just verifying whether that is allowed.
We have historically not done that, and so it would be my preference to continue it to the next hearing. If Ms. Dorman, are you checking the code or?
Yes.
Okay.
And I think if you want to continue it, you certainly may.
All right. Then, ma'am, if you could come forward. Yes, you could come forward. Let me tell you, they contacted the applicant for the petition you're here to speak about, and he is working and not able to attend the hearing. So we're going to continue the whole hearing to next month's land use hearing officer hearing. And I apologize you coming down and not being able to testify, but I can't open the hearing without him being here in his testimony. So we're going to continue it to the, what would be that hearing date?
I believe it's September 26th. Yes, September 26th.
So it will be back next month at September 26th at 10 a.m.
Okay, I have a couple of questions.
Sure.
One of those being, will we receive a notice, the same people?
Ms. Marshall, will they have to renotice?
I'll have to double, I believe they will. And actually, Carmen just told me that it'll actually need to continue to September because we've missed the notice deadline for August.
Oh, I thought I said September. What was?
I'm sorry. Yes. you
So
did.
it's September.
September
26th. Is that the date?
Yes.
Carmen's trying to talk to us.
Sorry.
Yeah, no, they missed the deadline for the September hearing. That was on Friday. So they will actually have to go to October.
Oh, to October. And what is that date, Carmen?
It's October 23rd.
October 23rd. And can you confirm that they will have to renotice? Is that correct?
I just want to, pardon me, I want to confirm that the same people receive the same notices in sufficient time.
Let me just have staff confirm that for you.
Yes, they will need to renotice.
Okay. Yes, ma'am. The same people that were noticed, they have an adjacent property owner list. They will have to renotice for the October 23rd hearing.
Okay, the next question is, some of those people were unable to come today in opposition, and they did submit letters to that effect online.
Those
Will they
records,
have to resubmit those, or will they continue forward from today?
no, if they submitted them to the county, they're a part of the file for this application, so they're a part of the county record.
Okay, I just wanted to confirm those two things because I know they terribly wanted to be here, but could not. So
All
they
right.
took the normal steps to make sure that their voices were heard one way or the other.
Absolutely. If you could just pass along to those people that, I mean, they will receive notice if they're within the notice distance, specify the code, but it will be October 23rd at 10 a.m.
As long as we all get the notices to remind us.
Thank you. Yes,
right,
understood.
thank you.
Thank you for coming down. I apologize for the delay.
Thank you.
All right, then, oh, I'm sorry. Yes. So then, Ms. Marshall, we'll continue on with the hearing.
Next item is item H3, variance 230529. The applicant is Angel Gonzalez. The request is a variance to fence requirements. Staff findings will be provided by Chris Granlinard.
Good morning.
Good morning.
Chris Granlinard, Development Services. Here to present application VAR 23-529. The applicant is requesting a height variance for an existing fence on property zoned PD 76-0166. Per LDC section 6.07.02C.1.f, the maximum average height of any fence shall be 6 feet except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase to the maximum permitted height to allow an 8-foot high fence along the eastern property boundary. Findings: during staff review, it was discovered that the existing 10-by-6 storage building on the north side of the lot It's closer to the street than part of the house. Therefore, it must meet the principal structure side yard setback required by the PD, which is 7.5 feet. The applicant advised staff that they do not wish to add the storage building setback to the variance application. The subject fence is subject of a code enforcement case, which has been placed in the case file. This is one of 2 other variances that are neighbors that are seeking the same variance. Any questions, I'll be glad to answer.
No questions at this time. Thank you.
Thank you.
Is the applicant here? Good morning.
Good morning, Madam Hearing Officer. Todd Pressman, 200 2nd Avenue South, number 451 in St. Petersburg. Thank you. Yeah, that's good. Great. Thank you. This is variance 23-0529. Mr. Gonzalez is here to have a few words with you as well. The address is 16405 Oak Manor Drive, and as I saw you shaking your head, there are 2 others following here that are somewhat related, just for orientation purposes. So the variance is based upon a number of factors. The critical one is the increased elevation of the Wood Acre development, which is abutting to the rear of this home. The second aggravating factor is a unique shape and twist of Wood Acre Lane on Mr. Gonzalez's home. As you can see, the road takes a very hard twist, which pushes that elevation right up against their homes, which is not prevalent anywhere else in the subdivision or anywhere in the immediate area. And the third is that's caused clearly by impact of wetland area. So from the Fish and Wildlife National Wetlands map, you can see the wetlands and the requirement for the roadway clearly to be moved or changed. And a zoom out, as you can see, the condition of that roadway is unique and singular as a condition. And that follows by the elevations on the Hillsborough County contour map, which show a difference of height from the roadway up to the top of that roadway or bank. This is a view just to show you the difference between a 6-foot and 8-foot wall from Wood Acre. And it begins to show you that the concern here by Mr. Gonzalez is what you typically would have with a 6-foot fence, which is privacy, security, and safety. This is a view of Wood Acre. You can see truck there and the roadway, and you can see again the elevation, which is clearly prevalent, as you can see here. And again, this is maybe a little bit exaggerated, but to show you well, there's significant elevation change, which we've documented to you. So when you look at the variance criteria, that there's hardship, practical difficulties, the unique and singular, I think we've clearly shown and presented to you that these are unique and singular to this particular property and maybe 1 or 2 others just in the immediate area. It does deprive the right of the properties to have the same rights of safety and privacy and security at their homes, whether a 6-foot or 8-foot fence. Clearly, the elevation negates what other properties in the county have as a 6-foot fence, allows it to exist as what a 6-foot fence would look like. We don't believe that it interferes with the rights of others, and I do have to put in the record 2 letters signed by the 2 property owners to the rear. It's a Mr. Martinez at 4101 Wood Acre Lane and Mr. Lopez at 4103 Wood Acre Lane, which are the 2 residential homes that would be the only ones that would abut this property or the others, and I'll put this in the record. So we don't see how beyond those 2 there would be any effect or any impact of negative elements or injury rights to any of the property owners. The variance would be in harmony, serves the general intent of the purpose of the LDC clearly, because 6-foot fences are allowed to provide for safety and security and well-being, and this would at 8-foot provide that where 6-foot does not. The result or the variance does not result from a legal act. It results from elements which we presented to you that are outside the control of the applicant, which would be the shape of the road, the elevation, and clearly the attending to the wetlands by the developer of the property abutting. And that does not result from a legal act of any kind that we're aware of, and would result clearly in substantial justice being done considering public benefit and the individual hardship that's being carried by the property owners. So with that, I'll put these letters in the record, and Mr. Gonzalez would like to make a couple comments if we may.
All right, and then I have a couple quick questions, but however you prefer to do it. Good morning.
Good morning, ma'am. My name is Angel Gonzalez. My address is 16405 Oak Manor Drive, Tampa, Florida. I'm the applicant for this variance, and I just have a short statement that I would like to read. I'm a layman when it comes to matters such as this, so if you would bear with me. I'm writing to explain the urgent need for variance for a fence around my home. The 8-foot high section of fence for which I'm requesting a variance runs along the rear of my property. I think it's necessary for privacy and safety due to the significant difference in elevation with the property behind my home. According to neighbors who are also facing similar issues of their own when they moved into the house in the 90s, the land behind the properties was an open parcel of land surrounded on 3 sides by houses, and the 4th side was a fully was an open parcel of land with a swampy area and mature cypress trees. Back then, they were told that the property would never be developed, but later, around 2001, development started in this land, and truckloads of dirt were brought in to raise the level of the terrain, causing the significant change in elevation, which affected my property. Due to the above, the prior owner of my property put up an 8-foot fence, which was standing when I purchased the home back in 2016. I since replaced the fence in 2020 with a fence of the same height, unaware about any height requirements. At its current height, because our home has large sliding glass doors and windows facing the backyard, the lower fence would allow anyone on the nearby sidewalk or road to look directly into our kitchen, our family room, our master bedroom. In addition to the entire backyard, we would have to live with curtains closed 24/7 to have any privacy. Having a dark wooded area in the wetlands behind the home would also allow anyone to potentially hide behind the house, and passing cars would be able to shine their lights as they drove near the rear of my property. Based on the above, I would like to respectfully request that you take all these matters into consideration when you consider whether to approve my variance.
Mr. Gonzalez, let me just for my notes, you said that a prior property owner installed the 8-foot fence. What year was that? Do you know?
When I moved in 2016, it was already an old fence, so it would, in my estimation, it would have to have been at least 15 or 20 years old.
Okay, so you bought it in 2016,
Yes,
and then
ma'am.
you replaced that 8-foot fence with your own 8-foot fence in about 2020. Is that what you said?
Yes, ma'am.
All right.
Correct.
And then finally, do you know how these code enforcement matters came to light? Do you know how this happened?
I believe somebody else was being looked at in terms of, or their own fence, and might have brought up the issue of our fences.
I see.
But we had, at least my fence, I know had been long-standing there for many years, and it was never an issue before.
Understood. All right, thank you so much. If you could please sign in with the clerk's office. Mr. Pressman, anything else?
I would just place emphasis in the last question that the hardship and singular nature are the topographical, geographical conditions I presented to you. That creates a supportable variance, and those elements were not created or done by an illegal act. So we feel that it still justifies the criteria, and particular criteria that I'm referring to in terms of legal act. Thank you.
Thank you, I appreciate it. Sign in if you haven't. All right, is there anyone that would like to speak in support? Anyone in favor? Yes, sir. While he's coming up, is there anyone else that would like to speak in support? Okay. Good morning.
Good morning. My name's Thomas Murray. I live at 15751 Gardenside Lane. For you Southerners, that's a place where you grow things, a garden. All right. I am presently president of the Northdale Special District, and I was also president of the Northdale Civic Association, where we have some of our responsibility deals with deed restriction violations. So when I saw that these three neighbors together had sign up for a variance and stuff like this, I went and actually paid a visit to one of them saying, what's going on here? So I went out and I visited the sites, looked at the fences, drove around the other side, and basically what they ended up having was these three houses have this fence that's probably non-conforming, but if without it, they might as well not have any fence, because two of the lots, there's nothing in back of it, and one of the lots, there's another house who I do believe helped pay for half of the fence because he understands the problem of the person sitting in the lowlands, if you will. And it really is a unique situation for Northdale, because we don't have that much elevation going like this. And for them not to be granted this would really be a hardship on them as far as any privacy at all goes. And so I know in our position, we do not have any issue at all with what they're trying to attempt.
All right, thank you for coming down. I really appreciate it. If you could please
Thank you.
sign in. All right, anyone else to speak in support? Seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, thank you.
All right, Mr. Pressman, you have the last word if you'd like it.
No, we appreciate this gentleman being here and hoping he's sticking around for the next two.
All right, I'm
Thank you.
sure. Thank you. And so with that, we'll close variance 23-0529 and go to the next case.
Next item is item H4, variance 230530. The applicant is Zohara B. Peters. The request is a variance to fence requirements. Staff findings will be provided by Chris Granlenard.
Hello again.
Hello again, Chris Granlenard, Development Services. Here to present application variance 23-530. The applicant is requesting a height variance for an existing fence on property zone PD 76-0166. Variance per LDC section 6.07.02.c.1.f. The maximum average height of any fence shall be 6 feet, except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase to the maximum permitted height to allow an 8-foot high fence along the eastern property boundary. Findings, during staff review, it was discovered that the existing home does not meet the 7.5-foot side yard setback required by the PD zoning. The applicant was advised, and they said they did not wish to add the side yard setback to the variance. The subject fence is subject of a code enforcement case which has been placed in the record. That concludes my staff report.
No questions.
Okay.
No, thank you so much. We'll turn to the applicant.
That's it. Oh, okay. Thank you. For the record, Todd Pressman, 202nd Avenue South, number 451, St. Petersburg. Appreciate your time today. Oh, that's up. Thank you. This is variance 23-0531. This is variance 230530. That's what we're on, correct?
Correct.
Okay, thank you.
Yes.
For Ms. Peters, Ms. Peters is here at 16403 Oak Manor. This is similar in circumstances to what we've seen before, and this is all on the record. The increased elevation of Woodacre development, unique shape twist of Woodacre Lane, impact of the wetlands caused by the impact wetland areas, and shown here in the same manner as the last case. And again, you'll see the same elevation pictures. To run through the variance criteria would be the same as before. Unique and singular condition is caused by those 3 topographical features. It would deprive them the rights what typically found in a 6-foot fence versus a 8-foot fence in the county. Would not injure the rights of others. We have the budding neighbor on record from the prior case. I would ask that those letters be applied to this case as well. Serves the general intent of the LDC in terms of what a 6-foot fence allows versus the elevation, which demotes the intent and allowance of that sign. Does not result from a legal act, results from the topographical, geographical conditions, and clearly the public benefit for the individual hardship would be suffered if failed to grant the variance. So with that, we're happy to answer the questions you might have.
No questions at this time. Thank you. We'll go to anyone who would like to testify in support. Yes, sir.
I'm sorry,
Please.
Ms. Peters is here.
Oh,
so I
would she like to
apologize.
speak?
I was going
Absolutely.
to just a few comments.
Absolutely. Good morning.
Hi, good morning. I'm Zohara Peters, 16403 Oak Manor Drive, Tampa, Florida, 33624. So my daughter and I'm a single mother with a disabled daughter. She's 30 years old. She's mentally and physically disabled. So when we first moved to our home, the fence was 6 foot, and I was not aware of the problem behind the fence with the wood acres, I was mainly buying a home, looking at the property, and we moved in. Shortly, this was in January 2016. So shortly after we moved in, I realized that, in the back, you can see, because the fence is 6 foot and the elevation is, 4 foot, behind the property, the trucks, when they drive down, they can see through my home, my backyard, the entire screen porch, going through my master bedroom, all through my bathroom. And there's, so the first year or so, I have to lock my, bedroom door, the bedroom, the blinds, 24/7, okay? And my daughter is mentally and physically disabled, so I'm always cautious about her. So there were 2 incidents that I would like to address, okay? And this is in 2016 to 2017. Somebody behind the property, okay, took a ladder, put behind my fence, climb up, and say hello to my daughter. Say, hi, how are you? Hi, what's your name? And we were sitting in the patio, screen patio. So I came out, I said, ma'am, it was a woman, and I believe there was a man, behind her on the thing. I said, ma'am, you cannot do that. This is my property. And she said, no, she said, what happened to your daughter? What's wrong with her? I want to know, So I did not answer it, and she got angry, okay? So that's when I'm like, ding, 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 I just moved here. What the hell am I going to do, right? So I did contacted the sheriff office, and they informed me that if this happened again, to call them, okay? Well, the next year, I believe, I think it's August 2017, we have Hurricane Irma. And my back, 2 of my panels was damaged, knocked down by Hurricane Irma, and the side panel, which is next to the next applicants, the Crosby, their panel and my, we shared, the entire panel was knocked down. That's when I decided that I'm going to replace my back fence with an 8-foot fence, okay? And we did it together. So, and those were the 2 incidents that, I would like to address. And I appreciate, I'm sorry?
Very good.
Yeah, and I appreciate that you do the right thing, which is to give us the approval for the fence for all 3 of us, okay? I use the background the backyard to help my daughter with, for safety, healthy, and to increase her, quality of life, okay? I don't want her to stay at home 24/7 looking at the wall. So we are out there, quite a bit now that we have the 8-foot fence. So thank you so much for.
Let me ask before you go. Let me ask you one thing. So when you replaced it after the storm damage and increased the height to 8 feet, the neighbor, the previous case, the neighbor's fence was also at 8 feet at that time.
So
correct?
what happened is that I moved, so the neighbor next door, which is Angel, he already have 8 foot.
Yes.
Crosby already have 8 foot, so I was at 6 foot, you know? So when I increase, we are all at 8 foot.
Understood.
So, and that is also reduce the noise for all of us.
All right, thank you for coming down, I
You're
appreciate it. Mr. Pressman, anything else?
No, we appreciate your consideration. Thank you.
All right, thank you so much. All right, we'll take testimony in support. Yes, sir.
Do I go through everything again?
Yes, unfortunately, or fortunately, this is a
Okay.
completely separate case, so we have to maintain its own record.
Thomas Murray, 15751 Garden Side Lane, Tampa. I am currently president of Northdale Special District, and I was president of Northdale Civic Association. We deal with deed restrictions and so forth in our neighborhoods. I visited the sites that are in question, and really and truly, without this variance, it puts a hardship on them as far as any privacy at all goes. And you know, we have zero issue with it, and we would support it wholeheartedly.
Perfect, thank you so
Thank
much.
you.
If you could please sign in again for this case. All right, anyone else to speak in support? Seeing no one, anyone in opposition to this request? No one. Ms. Marshall, anything else?
No, thank you.
All right, Mr. Pressman? Good, all right, then we'll close variance 23-0530 and go to the next case.
Next case is item H5, variance 230531. The applicant is Carol A. Crosby. The request is a variance to fence requirements. Staff findings will be provided by Chris Granlenard.
Hello.
Hello again, Chris Granlenard, Development Services. Here to present variance 23-531. The applicant is requesting a height variance for an existing fence on property zone PD 76-0166. Per LDC section 6.07.02.c.1.f, the maximum average height of any fence shall be 6 feet except under certain circumstances that do not apply in this case. The applicant requests a 2-foot increase to the maximum permitted height to allow an 8-foot high fence along the eastern property boundary. Findings: the subject fence is the subject of a code enforcement case which has been placed in the code record, in the case record. That concludes my staff report, unless you have any questions.
No additional questions,
Thank
but
you.
thank you. Turn to the applicant.
Thank you. Thank you. Good afternoon, Todd Pressman, 202nd Avenue South, number 451, St. Petersburg. The county had an ad in the paper, 3 for the price of 1, so we took them up on it. We're doing all 3 here now. I would ask again the couple letters that were submitted previously be applied to this site as well. This is basically the same presentation. You can see the orientation of the Crosby home. Ms. Crosby is here behind me. Again, there we go. Again, same circumstances, elevation, unique shape, twist of the roadway, impact of the wetland areas, which you become aware of, the contours from the county zoning or viewer map, and showing you the difference between the 6 and 8 as it applies to the homes and the elevation that can clearly be seen by the photos. So again, in same regard, to be very brief, we believe the hardships are unique and singular to just these particular properties as they exist along the twist of the road. Does not apply to any other homes in the entire subdivision or elsewhere in the vicinity. It does deprive them the rights of typically found for a 6-foot fence, which is lost because of the elevation. Would not injure rights of others. We haven't heard from anyone in the public, and we're hearing from the nice gentleman who came down on behalf of the area of the county. Certainly serves the intent and purpose of the LDC in terms of being harmonious, asking for fencing that everyone else does enjoy. Does not result from a legal act as topographical, geographical conditions, and certainly would provide substantial justice concerning the hardships as presented. So with that, we appreciate your attention and consideration.
Just one quick question to ask, if when the property owner purchased this property, if the 8-foot fence was existing?
Ms. Crosby is indicating no, and she'll make a few comments when I'm done, or when we're done.
Perfect, thank you.
Thank you.
That was my only question. Good afternoon.
Hi, good afternoon.
Give us
My
your
name's-
name and address.
Oh, Carol Crosby, 16401 Oak Manor Drive. And we've been in our house for a while. We moved in 96, and when we moved in, the property behind us was just open. So our house is, was developed back in 1978, or 1978, 1979 was when it was built. And when we moved in, the fence in the backyard was a 6-foot fence. There's nobody behind us, and that's really what we were looking for, is just, something a little secluded like that. I'd say back in 2000, 2001 is when they started to develop the property behind us. They cut down a large portion of the wetland area, that's fine, but they built up the entire property at least 3 feet. And with that, when the house started being built in 2002, the one directly behind us, they were able to look right into our backyard. The construction workers are out there, I was a young mom at the time with little kids. They're looking right into the backyard, and that includes our kitchen, our family room, and also the porch and our master bedroom. The whole thing is open. So it was really uncomfortable during that time frame. But then once the house was finished, somebody moved in, and they could look, since we're so much lower than them, because the property's 3 feet, and then you have the slab on top of that, they're looking right into your backyard. The house is built with a 0 lot line. It's the back of it just abuts right up to the easement. So they don't have any backyard. The backyard they have is the easement. And with them being so much higher than us, and then we're so much lower, they're looking right in. And at one point, we're seeing each other in our houses. And there was one day, a particular day, where they were waving at us, like, "Hello, how are you?" And you're in your kitchen, you're like very uncomfortable. So that's when we made the decision. We're going to go ahead with their approval, the neighbors behind us, to go ahead and put up a larger fence. They didn't have any problems with that, and we did that, I think, 2003. And so we had the fence has been there 18 years. So it's been there a long time. We replaced it back in 2017 because the fence was getting old. And the neighbors behind us, the ones that were waving at us, they went ahead and paid for half of it at that time, which was very nice of them. So we've been, it's provided harmony between our two homes. It's given us privacy, peace of mind. Without that fence, again, it just really would deeply affect the way we live our lives. Having to, you just have no privacy in your backyard or the back of your house. You really would almost have to worry about what you're wearing in your kitchen. So it just, we're asking that you would consider this variance and approve it.
All right, thank you so much. Thank you for coming down. If you could please sign in. Mr. Pressman, does that conclude your presentation?
Yes, thank you.
Okay, thank you. Then we'll call for anyone who would like to speak in support. One more time, sir. Thank you for coming down.
It's good, because I'm getting old. I have to remind myself all this stuff anyway. Thomas Murray, 15751 Garden Side Lane, Tampa. President of the Special District in Northdale, and was president of the Northdale Civic Association. And we deal with a lot of these issues, including deed restrictions and stuff. I went out and visited the site, and really and truly, with the elevation in Northdale, which there isn't any except for this area, I guess, without a fence at all, they would be deprived of any privacy at all that they have there. So we totally support this variance and hope you rule favorably.
Thank you again. If you could please sign in. Anyone else to speak in support? Seeing no one, anyone in opposition to the request? No one. County staff, anything else?
No, thank you.
All right, that's all for you, Mr. Pressman? Correct? Thank you. Then with that, we'll close variance 23-0531 and go to the next case.
The next case is item H6, variance 230532. The applicant is Root Project Management Group, LLC, Ruth Londano. The request is a variance to accessory dwelling requirements, lot development standards, and fence requirements. Staff findings will be provided by Tanya Chapello.
Good afternoon.
Good afternoon, Tanya Chapela, Development Services. The applicant is requesting setback variances to accommodate an existing single-family home, a proposed accessory dwelling, and a fence on a corner lot, zone RSC6. So we have the variance for the main house. Goes per the Land Development Code, Section 6.01.01, the required minimum front yard setback for property zone RSC6 is 25 feet. The applicant requests an 8.5-foot reduction to the required front yard setback to allow a front setback of 16.5 feet from the east property line. I'm going to So, yeah, the structure to the north is the main house. Then we have this structure to the south, which is a garage being converted into an accessory dwelling. And then in the middle of two structures, there is this fence. So this would be one front yard, and this is the other front yard. Now, in regards to the accessory dwelling variance, per the Land Development Code, Section 61102E, accessory dwellings shall meet principal building setbacks. Per the Land Development Code, Section 60101, a minimum front yard setback of 25 feet and minimum side yard setback of 7 feet are required in the RSC 6 district. The applicant requests the following: a 0.6-foot reduction to the required side yard setback to allow a side setback of 6.9 feet from the south property line, and a 1.9-foot reduction to the required front yard setback to allow a front setback of 23.1 feet from the east property line. The last variant would be for the fence. For the Land Development Code, Section 60702C1A, a maximum height of 4 feet is permitted for fences located in required front yards. The applicant requests a 2-foot height increase for an existing fence within the required eastern front yard to allow a height of 6 feet. As a findings, it's just like a minimum parcel width of 70 feet is required in the RSC 6 district. The subject lot is approximately 68.3 feet in width and is therefore non-conforming. However, it has been certified as a legal non-conforming lot per non-conforming lot application 23-0722. And this concludes my presentation. Thank you.
Thank you. I appreciate it. All right. Is the applicant here? Good afternoon.
Good afternoon. Let me see the... Okay, Ruth Londono, 1502.
Could you bring the microphone just a little closer to you? There you go. Thank you.
Okay. Ruth Londono, 10502 West Bush Boulevard. I'm here to represent the owners, that is Kiara and David Garces. They are daughter and father, okay? We are requesting 3 different variances. One for the principal dwelling, that is this one in the front, and they convert the existing garage with no living area into a living area that got to be request the permit by building department as an accessory dwelling. And the third is for the fence requirements. The current, let me see, okay. The first is a detached for the detached garage that is located on the south. The second is the number 3 variance that is for the principal dwelling that is on the north of the property. And the third case is the fence requirements to increase to 2-foot height. For the existing garage, we are requesting 2 variants, one to the front setback and the second one to the side setback. The property is located on RAC6 zoning district. For the requirements are the front setback is 25, and we are requesting to reduce from 25 to 23.1. That is a reduction of 1.9 foot. That's going to be on the front yard, the second front yard, because this is a corner lot. The second requirement is for the side reduction for the side setback. That per zoning requirement is 7.5. We are requesting to have a reduction 0.6 to left to allow 6.9 setback. The reason the owner is requesting this one for the accessory dwelling is because they come here, the sister and daughter. The sister is come from the country around 1 year, and they want to allow the family member to live in a separate building but on the same property. Per Land Development Code, the accessory dwelling is allowed to request by family members that got to be applied for this one. But in order to apply for accessory dwelling, that must to meet the regular setbacks. That is the reason we are requesting the front and the side setback. The next one is the next requirement is for the existing building, the principal dwelling, that have we are requesting to reduce the 25 front setback in front of North Gomez. On West Jean is already have the requirement more than 25 feet, but on the west front yard, they have only 16.5. We are requesting to reduce the front setback from 25 to 16.5. That is a reduction of 8.5. Okay, that is a cross line. You see that for the requirement number 4. I'm sorry that we crossed that one. But we go to the next requirement that is for the fence height. This is a corner lot with 2 fronts, but they have just a portion. From this, as you see on the little picture in here, they have only this portion of the fence that is inside the front yard that allow only 4 feet height, and we are requesting to increase 2 foot and to reduce the setbacks from the 25 to the existing is to reduce to 9. That we have the setback for the fence to allow the 9 and increase the fence height to 6. This is thank you for listening this one today. I finished with the presentation. If you have any question.
My only question was, if you know, was the house, I see that the deed shows the property owner bought the property in 2021, and if the house was encroaching into that front yard setback at that time, was it as is?
This was interesting because I was looking on the property appraiser. The house was built on 1958. Initially, the principal dwelling was built on 1958.
Okay.
The same location. I was looking on the aerial photograph for the property appraiser, and the back that I can go is 2006. The house has been built there for all this time. Between 26 and 1958, there was the garage there. Okay, I was looking that I found in my research, I found that was on 2010, there was a permit to change the garage door for the garage building. And on 2006, 2007, there was another permit that was for the re-roofing. But according to answer your question, is yes, the house has been there, the building has been there from the, I think, 1958.
All right, thank you. That was my only question.
Okay, thank you so much.
Please sign in, I appreciate it. Is there anyone here that would like to speak in support? Anyone in support, either in the room or online? Seeing no one, anyone in opposition to this request? Yes, ma'am. While she's coming forward, is there anyone else that would like to speak in opposition? All right. Good afternoon.
Good afternoon. My name is Dawn Barber. I live at 3001 West Paris Street in Tampa, and we are the closest adjoining neighbors to the garage.
Okay.
We have no concern with the primary house or the fencing. Our concern is solely with the converting the garage to a dwelling. They've actually already done it illegally, and so we've experienced the people living there for 10 months. So speaking from experience, and at the start of this, we were, he said that his sister was coming from Cuba, so we wanted to give them the opportunity to, okay. He promised that they would be respectful and considerate, and it was a miserable 10 months and just made us very unhappy. We spent a very long time looking for our house. Huge consideration went into the outdoor area. We wanted some privacy and peace and quiet, and we have a pool out there. We spend a lot of time out there. That was the first thing that we updated, got furniture for. We love being out there, but they moved in, and there was constant noise from sun up to sundown. Other neighbors might go out and have a big party once a month, and it's loud. They didn't, so sometimes they did that, but my concern is because they're so close to us, because they don't meet the minimum setback, and everything is contained, like they fully fenced them in. There's no go-between or anything. They fenced them in on our side of that garage that's not set back far enough. So all the traveling, the coming and going, the slamming of the gate, the leaving the door open to yell to each other from inside and outside, and this living area they've built out there is all contained within that too small of setback. And it's, we're kind of, best case scenario would be a quiet couple that maybe was inside more, and they're outside all the time. And so there's just constant noise, and so let's see. So this is what, the other thing is, there used to be from the, I'll put this one up so you could see it closer. From the listings of when they bought their house. That's the photo of the garage. And you can see the door is on their side. And they closed that up and made this fence here taller, and then added a fence back there in the back without any go-between, so that they'd have their own privacy, and they put it all on the burden on our side.
Let me ask you before you take this picture off. So in the picture, the upper picture, behind that I see a PVC fence with like the lattice work and a pool screen. Is that your house?
Yes.
Okay.
That's our house.
Thank you.
So the fact that they removed the door from their side and put it on our side, and then put up a fence so that they weren't bothered by all the additional vehicles and foot traffic that's coming and going all the time. I mean, it kind of says that they knew that there would be a disturbance created, and they wanted to preserve their privacy and quiet, and they weren't really concerned with ours. So there's the little inset of that house, but it was on that side, or the door, sorry. The door was on that side of the garage, and then they closed that up. I don't know exactly what it looks like on their side. I just know that they've left the door open enough times that I know that what was the door through there is now the bathroom. So they've closed that, and then you can see they've added, like, this is their door. I'll scoot this up. You can also see that pool right there, that's our area. So that's where we spend a lot of time.
So the house now, the accessory house now is oriented towards your house?
Correct.
Whereas previously it was oriented towards the garage was oriented towards their house?
Correct.
To say. Okay,
Yeah,
understood.
so they went out of their way and put, I showed here, this is the door, there's 2 windows, and then there's a walkway, like a patio here that I'll show that later, but there's, they put up it's more of a temporary gazebo kind of awning, but I'm just a little closer of what they've what they've added. I mean, it just there's like 6 cars crammed in there that weren't there before they converted it, aren't there after. A lot of foot traffic coming and going, and they never used that area before they converted it, and they haven't used it since the people moved out. So there's really not a reason with the large area on the other side of the garage that they'd even use this area. But they do or did when it was a dwelling. So I'll just show you before. This is as we bought it and what we expected it to stay, because the garage doesn't meet the minimum setback requirements to convert it. So that's what we kind of expected, with a solid backdrop and, you know, not a lot of clutter over there and not people coming and going and hanging out on that side all the time. And then this is what they did. You can see the blue construction tarp that they used for a canopy for a couple months until they moved out. There was also stacks of used tires that would go over the fence, and we asked them if they could move them, or at least, you know, lower them so they weren't, because that now became the backdrop to our pool that we had enjoyed before. And we were told no, and they left those up. So we did kind of try and talk to them and work with them, and they didn't have any concern, kind of laughed at me. But this, I felt kind of awkward because this is their area, but the picture is taken from our yard, and after they demonstrated for however long that they didn't have any concern for us and that they'd made all that noise, I started documenting stuff. So that's the living area that they put in that little back corner. That, once again, before they moved there and after they moved out, no one has used that area. They'd have no reason to use the area because there's a lot larger hangout area on the other side. And this is all the stuff that they put in that little corner. So I'm going to jump around, but also she said that it was for the sister. I understand that, but it was 2 people living there the entire time. And that just created a lot more noise than one person. We also don't think the way that they set it up and the fact that there was a different man living there for at least a few weeks after they moved out, that their sole intent is just for a sister to live there. And even if that were the case now, you know, this gives them approval for, you know, they can do anything they want with it in the future, and they've already shown that that wasn't its sole use. And for the fact that they've they didn't put a go-between, they've fenced it, they put it on the other side. It just seems like they're possibly setting it up as a rental that's not gonna impede with themselves, but, you know, as you can see, that it does impede with us. And this right here is just kind of to demonstrate that if you have a pull-out couch and sofas and an armoire with photos and candles and just all the stuff that they had out there, that's where they spent all their time. So they're out there from sun up to sundown, and even if it's not super loud noise, it's just constant noise. And then sometimes it was super loud noise because they'd have the speakers going, and they'd have definitely at least 7 people over at some of the times that they'd hang out, and it got quite loud for such a small area. And we're not just pointing this out because, you know, oh, they're noisy neighbors. The reason that they're back there is because if that's allowed to be a dwelling. And the reason why it's so loud to us and it sounds like we're in their living room and their kitchen is because it's not set back as far as it's supposed to be. They leave their door open a lot. We can hear the water running, the dishes clanging. It's just like we're in their living area because it's so close. So them specifically, it was a very loud nuisance, but anyone is just so close to our area that the coming and going from the vehicles and slamming of the gate and going in and out and yelling to each other from inside to outside, that was just all contained by the owner against our side. And so that's just more stuff along the way. It's just a ton of stuff along the fence that they use day in, day out, and just kind of more clutter with the awning and just more the windows, the doors, all that stuff on our side is visual clutter that just isn't the nice backdrop that we had when we spent so long making the decision of where we wanted to be. That's just another, I just wanted to show without the canopy, the tarp, the windows, the door, all the vehicles over here that they would, so that's just the difference. And then, let's see if there's just another backdrop. And honestly, I've got stuff, I just kind of went off book. I've got stuff that's like pointing out the kind of using more legal jargon and the noise disturbance of it, visual clutter, privacy concerns, the impact on the neighbors, not just us, but, you know, granting permission for the conversion in close proximity to the property line could set a precedent for future similar requests and rewarding a better to ask forgiveness than permission mentality. The cumulative effect of multiple secondary dwellings in garages or sheds without the appropriate noise mitigation measures could result in significant deterioration of the overall quality of life for neighboring residents. And then property values, you know, like I said, we spent a few years looking. We passed on some houses that felt like they were on top of each other, that had someone that close, and we purposely didn't go with that because we wanted some privacy and a little bit of space. And I feel like that, you know, for them to be able to do this, it now makes it like that. And I feel like it might deter people if we were to try and sell it. I guess
We've got
that's
about 3.5 minutes left.
okay. That's pretty much it. Like I said, there's more using the terminology of kind of more legal stuff, but that's the gist of it. And do you have any questions for me?
No, you answered my question. I think the pictures are very helpful as to what you're saying, so I appreciate it if you'd submit them into the record.
Okay, thank you.
All right, thank you, and don't forget to sign in as well.
All right, thank you.
Thank you. All right, anyone else? I think I asked, but let me just make sure. Anyone else to testify in opposition? All right, seeing no one, we'll go back to county staff. Ms. Marshall, talk to me about accessory dwelling units and the provision in terms of they have to have a kitchen, what the occupancy rules are in terms of the code, just sort of a brief overview of how that works.
Sure. So, let me just pull up the exact wording. So the accessory dwelling it's required to have a sleeping quarters, a kitchen, a bathing and toilet facilities. I'm sorry, what was the other question?
And the occupancy, it cannot be a rental, so forth, is that correct?
It doesn't have a restriction on the occupancy as far as a rental unit. The primary home is required to be owner occupied to allow for an accessory dwelling.
Okay, but it's from the neighbor's testimony, it's clear that this was done prior to the request for this to be an accessory dwelling unit. Is that your understanding? That it's acting, it appears from the pictures that it's acting as that currently prior to this request?
Correct.
All right, thank you. Did you have anything else you wanted to add?
No, thank you.
All right, then we'll go back to Ms. Lindano for rebuttal. You have 5 minutes.
Okay, when Rolando, when I was to counseling the owners, I was looking at some issues that they maybe have. They get a court enforcement because they was to remodel the garage. That was no living area into living area. Okay, that is not a kitchen right now, but that's not allowed for the code to live in accessory structure. To have the right to live must be in accessory dwelling. Okay, per land development code, the accessory dwelling, the living area is minimum 900 square feet. But they must to meet the requirements for the principal house setbacks. Right now, the dwelling, the garage is 720 square feet that meet the requirements for accessory dwelling. The second one is that let me talk about the land development code a little beginning with the Florida Building Code. You can have the doors in any wall, exterior wall. That's not a requirement. That's not a limitation. When can you pull the doors or where you can put the windows? You can have in any of the four walls or the exterior walls. I was talking with the owner because they told me that have a son speaking with the neighbors, and they was thinking to have the solution was to have a second fence. The owner have a fence between the two properties, and they built a second fence between both. Right now, there is a double fence on the south side for the lot. I was talking also with the owner to see if they are agree to relocate the door. And they are agreed to relocate the door because the more important right now is to allow and have the right that they have per land development code to have accessory dwelling when they are the primary owners that live on the principal dwelling, and they can have a family member that can live on the accessory dwelling. The owner is right now agree if they need to relocate the door, the front door, they can relocate to the other side that is on the, let me show you here. Okay, between the two buildings, the principal dwelling and the future accessory dwelling, that is around 23 feet. And between, if you see the survey, let me see, what is the survey? If you see the survey, there is like a little sidewalk that is between both properties. I recommend to the owner to relocate the door, and that's going to fix the problem that the owner, the next door they have. But in my real opinion, we have to reduce only 0.6 foot. That is around 7 inches.
Yes, I understand your point, but it's clear from the testimony from the neighbor behind that this is currently, or was in this past year, been used as an accessory dwelling, not consistent with the code, correct?
That they need to go to the building permit in order to have legal accessory dwelling. They cannot have the remodelation without permit. Right now it's a code enforcement. I was talking with the code enforcement, and the code enforcement was there, and they took some pictures, and that's no kitchen right now. Okay, they remove all the other things that was outside the building, like the blue awning that was there. They remove already everything, and what they can do right now is, if that got to fix the problem, they can relocate the door.
So I understand your position about the door. So there's no kitchen in it currently?
No,
All right.
that's no kitchen. You can have the code enforcement have proof that that's not a kitchen there. They have only like a little bar that is allowed to have an accessory structure.
All right, thank you. Let me just ask, Ms. Marshall, if this were to be approved, are they required to have a kitchen in there? In the accessory dwelling?
Yes.
Yes, okay, thank you.
That is the reason. That is the reason we need to have this one to meet the setbacks, to allow to have accessory dwelling that go to have a kitchen. Actually, the sister is working. She is working right now. They don't go to be there for all the time, like say for like 24/7, because they go to work. They have a lot of things to do outside the house.
All right, you've got about a minute left on the rebuttal. I don't have any further questions if you want to wrap up.
Okay, I have the presentation in paper. I can submit to the proof to the.
Yes, you can submit it into the record.
Okay,
Perfect.
thank you very much.
Thank you, I appreciate it. And then with that, we'll close variance 23-0532. Let's take we are long overdue for a break, so let's take a 5-minute break. If you could be back, there's a clock on the back of the wall at 12:50, and we'll keep moving. At some point, I think we are going to have to break for lunch because this is such a long hearing today. So, but for right now, we're 5-minute break. If you could be back at 12:50. Thank you. All right, everyone, if you could please take a seat. We're going to reconvene the hearing. Welcome back to the July 31st, 2023 Land Use Hearing Officer hearing. Get everybody to take a seat, and we'll keep moving. Ms. Marshall, we are ready to call the next case.
Next item is item H7, variance 230551. The applicant is Victoria Rowe. The request is a variance to fence requirements. Staff findings will be provided by Camille Kraka.
All right. Good afternoon.
Development Services presenting variance case 230551. The applicant is requesting a setback variance to accommodate an existing driveway entry gate and side yard fence on property zoned RSC 6. Per LDC section 60702C1, a maximum fence height of 4 feet is allowed in required front yards. The applicant is requesting a 1-foot increase to allow a height of 5 feet for an existing metal driveway entry gate, approximately 20 feet in width along the north property line. Second variance request is per LDC 60702C1F. In residential districts, the maximum average height of any fence or wall shall be 6 feet. The applicant is requesting a 2-foot increase in the permitted height to allow a height of 8 feet for an existing solid vinyl fence, approximately 104 feet in length along the east property line. And the visuals show the height increase that they added to the 6-foot fence along the east property.
So is that an existing fence is 4 feet or?
In the front yard, it's 4 feet. I believe there was an existing 6-foot, and they added an additional 2 feet for privacy. They have applicant representative will explain a little bit more.
I see it in your second picture, the additional.
Yes.
Okay, perfect. Thank you so much. I appreciate it. Is the applicant here?
Yes.
Good afternoon.
Good afternoon. My name is Vanessa McCleary. I live at 15417 Carolina Estates Boulevard. I am a friend of the applicant and representing her here. The reason that she is requesting this variance, so on this side of the property.
If you could bring the microphone over.
Sorry.
Yeah.
On this side of the property, it is 6 feet in compliance. On this side, she raised it because of issues with her neighbor. He has been very verbally and threatening, and he scares her children. And in order for them to be able to enjoy the backyard, she increased the height of the fence. So it is purely for her safety and for her personal enjoyment that she is making this request. On the front, she was not aware that it's a decorative option that she took with the fence, and so she's asking for a variance to be able to keep, because as you can see, it is 4 feet all the way across. It's just the kind of cute arched fence at the front.
Okay. So that 8-foot fence that she wanted to, it's existing?
It's existing, yes.
Perfect. All right, that was my only question.
Okay.
Does that complete your presentation?
Yes.
All right, thank you so much for coming down. If you could please sign in. All right, is there anyone here that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? Anyone in opposition? All right, seeing no one, Development Services, is there anything further?
No, thank you.
All right, ma'am, you have the last word if you'd like it.
The only other thing that I would mention is that code enforcement and law enforcement are both aware of the issues between the two neighbors, and it's the only thing that she could do. She did look to get a restraining order, but was afraid that that would antagonize him, and so she hasn't done that yet.
I see.
Thank you.
All right, thank you for that. Then with that, we'll close variance 23-0551 and go to the next case.
Next item is item H8, variance 230564. The applicant is Brandon and Jennifer Stevenson. The request is a variance to lot development standards. Staff findings will be provided by Isis Brown.
Good afternoon, Isis Brown, Development Services. This is variance 23-0564. The request here is for variance to side yard setbacks to accommodate an existing single-family home on a property zoned PD 981513. Per PD approval conditions, the setbacks are a side yard of 5 feet required. The applicant is requesting a 0.2 foot reduction to the required side yards to allow a setback of 4.8 feet on the northern and southern property lines for an existing home. There is an existing building permit, HC Building Permit 23-0049409, which was issued for a proposed addition, which is what triggered this variance. And I'm going to put the site plan down so that you can have an idea. Existing structure here, and it's saying 4.8 and 4.8 on the north and south. And so that's what the request is for. I'm available for any questions.
No questions at this time, but thank you.
Okay.
Is the applicant here?
The online? I believe this one's online, I think.
Is the applicant here for variance 23-0564?
I'm not seeing anyone on virtual.
All right, just to be clear, for anybody in the room, this is application agenda item H8. H8. No one. All right, then, Ms. Marshall, let's have Carmen try to contact the applicant and see if we can pick it back up in a little bit. We'll hold this application and move on to the next one.
Next item is item H9, variance 230601. Applicant is McNeil Engineering Incorporated, care of Christopher S. McNeil. The request is a variance to the subdivision requirements of LDC section 3.05.05.2, the Lutz Rural Area Standards, and staff findings will be provided by Isis Brown.
Isis Brown, Development Services, variance 23-0601. The applicant is requesting a variance to the Lutz Rural Area Standards for a proposed single-family residential subdivision on a property zoned ASC1 and RSC6. The parcel is approximately 44.33 acres. Per LDC Section 3.0905, subdivisions of property zoned AM, AR, AS 0.4, AS1, and ASC totaling 20 acres or more in size shall utilize a variety of access measures for individual lots, including direct frontage on roadways, easements, and/or private extension flag lots. At 30% of the lots accessed by internal project roadways shall not front roadways and shall be accessed by easements and/or private property extension. The applicants request the following: a 100% reduction to the required 30% of lots accessed by internal project roadways be accessed by easement and/or private driveways extensions to allow for a 0% of the lots be accessed by easements and/or property driveway extensions. Findings: the preliminary plat for the proposed subdivision is currently in review under project number ID 6600 for a totaling of 17 single-family residential lots. And we're available for any questions.
Okay, no questions at this time. Thank you so much. Is the applicant here? Good afternoon.
Good afternoon, Madam Hearing Officer. We've got a PowerPoint we could bring up. In the meantime, my name is Tyler Hudson. My address is 400 North Ashley Drive. With me here, sorry. Thank you. With me here this afternoon is Sebring Sierra, who's the property owner and developer, as well as Chris McNeil, a licensed civil engineer who will likely speak in rebuttal. Can you see my screen? Great.
Yes.
So just to emphasize what Isis mentioned, we have a 44-acre property. It's a little bit of an unusual configuration. There is no internal roadway network. The blue star is at Sunset Lane where we are proposing access. That's the only access to the interior of the subdivision. And I would also note that the white cross-hatched area is owned by this same developer, same owner, not part of the variance request at all. That's not subject to the plat that's also been filed. Would emphasize that this is not a speculative variance that we're seeking. This is a necessary variance. It was actually a comment provided by Development Services in connection with the filed preliminary plat. This is really the last item we need to get fixed before that can continue to advance. We're proposing 17 home sites over 44 acres. The zoning does technically allow up to 1 unit per acre. As I'm going to mention, there's some significant hardships that prevent that, so I don't want to get up here and say it's going to be 44 acres if this doesn't get approved, but you could develop certainly far more than just 17 lots, which is all that we are proposing. And as you can see, those 17 lots coexist among a very significant amount of buffering and open space. It's also worth noting that the preliminary plat had 2 comments. One, you need to get this variance that we're here for today. The other was you need to vacate some right-of-way from literal plat book 1 of Hillsborough County. And the Board of County Commissioners unanimously approved that vacating 2 weeks ago. You can see on screen it's that sort of yellow area with 2 north-south running streets and then a little bit of a 10-foot alley strip running east-west. So that has been approved. We are here because we do not think that accommodating this 30% flag lot requirement actually does the job of preserving on-site environmentally sensitive resources and open space, which is what this subdivision standard is meant to address. We are subject to it because we're more than 20 acres and we are ASC1 zoning. Madam Hearing Officer is obviously very familiar with the 6-fold variance criteria, and I'm going to go through those each in turn now. Hardship. This is a very unusually shaped property. It's not just one square, it's a bunch of squares that all sort of intersect. There are very significant on-site wetlands, which you can see that's the gray area. Those are wetlands that are there that we cannot impact. And it's not so much the size of them that's a problem, it's a little bit more than 20%. It's really their dispersed location. It's not just one wetland. They're spread throughout the site, including one sort of where the text box parcel 2 is. There's a fairly significant one really smack dab in the middle of the site. We are also in a wellhead resource protection zone requiring our developable sites to be 1 acre of uplands. We do not have any internal roadway network. We have very minimal roadway frontage at all. Perhaps most significantly for hardship, due to prior development that existed on the site, and I don't believe actually any of these septics are on site, so that one illustration might be an error, but the protective radii cumulatively of all of those pre-existing wellhead facilities significantly limits where we can put future septic. So we're left with a site that is difficult shape to begin with, difficult to access to begin with. The application of the application of these protective radii from completely off-site developments significantly limits what we can do. The flag lot requirement, as I'll talk about now, is just that's really a non-starter. Flag lots, by their nature, typically are going to require some type of double depth. You're going to double stack a lot. You really provide only one of them with public access. The second one would be access through a private easement. The net land that's available for this development after applying the wellhead rules, the wetland mitigation that we need to do, our 100% compliance with technical standards regarding drainage and things like that, it just leaves us very little developable area for a project that also wants to maximize open space. And that's a choice the developer's making. This is a little bit of an unusual situation in that we're seeking a variance not really to maximize the development rights of the site, but actually to minimize them. It's actually a little bit more challenging here to do less. And that's because of the developer's commitment to making this a estate lot size, environmentally protective subdivision that that has more open space than what the code would require, because it's a better product. That's what he's trying to bring to the market. So we think here on the second variance application criteria that the strict application of the code would really undermine those LUT's rural development standards that prize preservation and maximization of open space. Third criteria is about the non-interference with others' rights. This isn't really a buffering variance request. This is a very internally facing site. And as you can see with what's on screen, we're doing everything we can to minimize any direct lot-to-lot buffering with adjacent neighbors. We don't believe that this variance request has any other impacts, any kind of externalities on the LUT's community as a whole that are different than what any by right development could do by someone going to the permit office. This variance, again, is necessary for this type of minimal number of lots, minimal density, maximal open space that we are trying to do. In terms of harmony with the land development code and the comp plan, I'd like to take this kind of separately. I've alluded to this first one. Section 3.0905 is what we're seeking relief from. That's the 30% flag lot requirement. The lead-in sentence is, in order to preserve on-site environmentally sensitive resources and provide additional open space. That is exactly what we are doing. What we are proposing is more in harmony with that lead-in sentence and phrase than what the strict application of the code would require, which would be a sort of a chopped up juxtaposition of oddly shaped lots and minimal open space. On comp plan, the comprehensive plan includes several neighborhood community plans, one of which is the LUT's community plan. The vision for that talks about remaining in touch with natural systems, wildlife, and the environment. And we would respectfully submit that it's strict compliance with this flag lot subdivision requirement that would severely undermine that, because due to that double stacking requirement, you'd have such little land left as to this particular piece of land to accommodate that respect for natural systems, wildlife, and the environment. And the community plan directs that development standards are intended to have the effects that are listed on screen. And of course, the good folks who write these are not soothsayers. They can't imagine every circumstance where this might be appropriate or not. But again, maintaining ecological balance, protecting natural resources, retaining natural areas, and again, the reference to preserving and encouraging open space. We need this variance to build fewer units than what the code would otherwise allow to make real these exact goals that are in the LUT's community plan in the comprehensive plan. And so while legally the comp plan supersedes the land development regs, we can sort of avoid that discussion entirely, because again, I think this variance shows that what we are proposing here is more in harmony with the comp plan than the strict application of the flag lot requirement. This is not a self-imposed hardship. I just needed a picture, so I just put the land as it is. This is not a code enforcement remedial situation. The land has been undeveloped for as long as we're aware. So this is not self-imposed. Finally, substantial justice. I say this at every variance hearing. I think as a philosophy major, I have a hard time with this one, candidly, because I'm not sure justice is really implicated by a flag lot waiver. But the LUT's community, it's clear what the community wants based on what the comprehensive plan says, that LUT's is intended to be an area that is rural in character, that prioritizes the preservation of natural resources in open space over absolutely maximizing density. This is not something in Tampa Heights or in an urban area. This variance is not only sufficient to make that possible, it is necessary. The by right imposition of that flag lot requirement would severely undermine the developer's ability to allocate land in this boundary to open space, because it would get gobbled up by the double stacking and the weird access requirements that would be required to accommodate that. We think it would be less environmentally sensitive, it would be greater density, and it would have less open space. And so we respectfully submit that what we've included in the record, this presentation itself, is substantial and competent evidence in support of each of these criteria. and appreciate your consideration. If possible, I'd like to add a couple minutes that we have left over to our rebuttal in case needed, but that's all I have, and I'm happy to answer any questions that you might have.
No, I don't have any. I think you covered a couple of questions that I had, so thank you for that. I appreciate it. If you please sign in and submit whatever you'd like into the record. All right, is there anyone who would like to speak in support? Anyone in favor of this application, either in the room or online? Seeing no one, anyone in opposition to this request? Yes, ma'am. Please come forward. While she's coming forward, is there anyone else that would like to speak in opposition, either in the room? Yes, if you could go ahead and come forward. Anyone else? Don't be shy. Wave your hand. Okay, come on forward. If you go ahead and come forward, it speeds this up a little bit. And let me ask, do we have anyone online that wants to testify in opposition? No? Okay. So we have 3 people. That would 15 minutes. That would be 5 minutes apiece, Michael, if you could start the clock when she begins to speak. Good afternoon.
Hi, my name is Mary Donovan. I live at 18806 30th Street, Lutz, 33559. We've had a lot of people want to come into Lutz and take agricultural land or land and do what this developer wants to do. It sounds wonderful. But earlier, you also heard during the variance 23-0529, Mr. Gonzalez say when he moved into his home, he didn't have to have a fence. And then later on down the road, land developers came in, dumped dirt, added more houses. Now, my dad always used to say, and he's lived in Lutz since 1960, you can't BS a BSer. So my only concern is, right now, 17 homes are great. Yes, you want to consider the harmony of the land and the development to keep the land as is. But my question is, are you bringing in septic? Are you bringing in wells? And who's to say down the road that we won't get dirt brought in to build up more housing in that area? Money talks, and those would be my concerns.
All right, thank you for coming
Thank
down.
you.
I appreciate it. If you could please sign in. Next, please. Good afternoon.
Good afternoon. My name is Lewis Owen. I'm at 18605 Lakeshore Drive. I'm on Lake Keene, and it's just around the corner from Yoakum. Yoakum is the street which is, this planned community could really affect very adversely. The driveways in the wet season on Yoakum literally fill up. I've seen them stand with water in their front of their homes for 5 days without draining. And the area that they say that they're leaving for wetland drainage is relatively small. I'm fearful that the housing, the raising of the land within this wetland area will flood those people out. Thank goodness for the county. The county has put in a drainage ditch in front of my house that does well. It drains into the canal there on Lake Keene, and it has kept us from flooding many times. I would like to see them, and that is the developer, to ensure that we don't have flooding. Somehow, the flooding or the drainage system should go south, should go towards Lake Stemper, which is quite a large lake, and I know that eventually it drains into Tampa Bay. And I would like to hear more about the drainage. Also, I furnish my own water with a well, and obviously I have a septic tank. Actually, I have two septic tanks. One septic tank pumps into another septic tank, which pumps out to the drain field. My drain field is higher than this desk that you all are sitting behind. And it does a good job right now. So all of those things are my concern, and I hope that you all, the county, will take a look at this with a very discriminating eye and make the right decision for us people who live in Lutz. By the way, I've lived in Lutz for 7 years only. My father lived there since 1950. So I'm familiar with Lutz, and that's where my heart is, and I hope that you all consider us in Lutz. Thank you.
Thank you, sir, for coming down. I appreciate it. If you could please sign in with the clerk. Good afternoon.
Hi, my name's Courtney Olson, and my address is 18603 Yoakum Avenue. And this is where I live. So I'm right across the street from
We can
where.
act towards you if you're gonna.
Where
The
we-
microphone moves.
Okay.
Yeah, there you go.
So this is where I live, and my concern, like he stated, is with the drainage. Now, what they're requesting as far as the flag lots, I have to say, I agree that the flag lots are, if we have to go in and anything needs to be done, the flag lots scare me more if they're still gonna be approved to build. However, the drainage, so like I said, I live on Yoakum, and all along this road, as he said, our lots flood. We all have significant drainage systems installed in our lots, so we're moving the water as quick as possible, but it's all coming off the street. And across the street, there's a little bit of downward going into the woods, which is their property, and that when we have, it's not necessarily like the runoff and stuff like that, it's the heavy rains. So if we're shortening any of this here, any of this land that normally floods all in here, if we're shortening it, then, I mean, there's nowhere else for that to go, but I can see going up over the road. And right now, because we're all maxed out at where we are, and we don't have any street drainage, we don't have anything like that, so we're maxed out. We've got our own personal drains, and we're just barely keeping water from coming in our house. If anything overflows or goes across the street, we're all gonna be flooded. And so that's my biggest concern with a development going in here. Again, like I said, I agree with their flag lots. If that's all we're talking about today, I don't think the flag lots are a good idea for this particular development. I've seen a lot of their things. I've been talking to them. I've seen a lot of their different plans and stuff like that. Their new request, I will address theirs. Their new request to have the roads touch all of the lots would mean that they're able to capture each individual lot's drainage and move it. And they've showed me how the retention ponds and everything like that. So what they're presenting in terms of getting rid of flag lots, I actually agree with them on that. However, I just see this piece of land, and I've lived here for a little while, I've seen that this piece of land is a scary place to build because there's so many drainage issues all around. And then in our neighborhood too, we've got septic systems that are starting to fail. We have wells that are starting to fail. So what's gonna be built on this land? Are we gonna tax our systems that are existing even more? My well, before I bought my house, dried up, so they dug it significantly deeper. What's gonna happen to the wells in the neighborhood, and how deep are the wells going, and how will that affect all of the surrounding neighborhoods? Same with the septics. Septics going in, we're draining. You know, I don't know the ins and outs of septic fields, but I do know that, you know, that water's gotta go somewhere, whether it's treated or not, and how is that gonna affect the surrounding neighborhood? So anything going in there to be built scares me, and I don't see how, I mean, that's pretty much it for me. So my biggest concern, personally, is the drainage overflowing, but I do know a lot of the neighborhood people and a couple others that have spoken has been a concern with like septics and wells and how that will affect our underground water and movement, and are we going to experience subsidence? That's another thing our neighborhood has. There's subsidence issues in our neighborhood. Is building on this, you know, lot that's in between them going to affect that with any of the surrounding neighborhoods? So that's all I have.
Thank you for coming down. I appreciate it. If you could please sign in. All right. Seeing no other opposition, we'll go back to Development Services. Anything further?
No, thank you.
All right. Mr. Hudson, you have 5 minutes. I'm willing to grant you a couple more if you need it for your expert.
Thank you, Madam Hearing Officer. I think 5 minutes should be plenty. Tyler Hudson, for the record. We'd just like to note at the outset that Chris, our civil engineer, and Sebring, who's the developer, has had some productive conversations with Mr. Owen and Ms. Olson. We'll make sure we get Ms. Donovan's contact information. Not that we're going to necessarily solve all of the drainage issues here, but it is important to be transparent and communicate. So I know that Sebring can commit to doing that after this hearing. We are here really for the four corners of a variance application to eliminate a flag lot requirement. That's really what we're seeking, and that's what our record of support is narrowly targeted on. But in the interest of transparency and being a good neighbor, I am going to ask that Chris get up and speak a little bit about some of these drainage issues. I would just note at the outset that we are not seeking any variance from any technical standards requiring stormwater attenuation, drainage, things like that. I think it's also worth noting that the standards, that there are infrastructure issues that are pervasive in this county and in the city. I think everyone's very aware of that. The standards that we are going to have to comply with, I believe, are different than the standards that development surrounding it complied with years ago. And perhaps that is one of the reasons we're in the position we are. And I'd like Chris to talk about how we are not just promising, we have to ensure that our impacts do not go onto Yoakum Road and the adjacent property owners. Thanks.
Thank you. Good afternoon.
Good afternoon, Madam Hearing Officer. Chris McNeil, 15957 North Florida Avenue, Luz, Florida 33549. As Mr. Hudson mentioned, and as some of the neighbors are concerned about the drainage, we will definitely fully comply with any and all drainage requirements that we have with the local Hillsborough County and SwiftMud criteria. There's also, just to point out, a great buffer that's been set aside from that area. There's mentioned a lot of wetlands on the site, and those are all preserved, as well as additional open areas to be able to maintain that. So from Yoakum, there's quite a distance of undisturbed area that will be able to be preserved from that. In addition to the stormwater criteria, there is some flow and connectivity information that we've talked to the neighbors about that we'll take into consideration while we're designing. At this point, we're only in the preliminary plat phase, so we have not gone into the detailed design phase. But at that point, that information will be useful to communicate with them and address any concerns that they may have.
Just to answer the first person who spoke in opposition, their question about whether well and septic will be used, is that what's proposed for utilities?
Yes, ma'am. Well and septic would be proposed.
All right, thank you.
I'd also like to mention on this particular layout, and this developer is not like most, but the layout is for 17 lots. It truly is an intent to try to preserve the nature aesthetics of the lots, with larger lots and less improvements, and with the driveway and the lot accessibility, the way the driveways the roadway is laid out, it's less impervious than it otherwise would be. So that also speaks to the drainage for this particular case. Less driveway, less impervious, less impact on the drainage. So I think all that works together for the case.
Understood. All right, thank you. About a little more than 2 minutes left.
Thank you, Madam Hearing Officer. We have nothing further. Appreciate your consideration.
All right, thank you for that. Then we'll close variance 23-0601. I see it's 1:30, and we have five more cases left. So I think it's appropriate that we break for a short lunch period. I would say a half an hour. This is unprecedented. In all the years I've been doing this, I haven't had to break for lunch, but I think that we need to for today. So 1:30, if you all could be back at 2 o'clock, and we'll resume the hearing to complete it. Thank you so much. Welcome back, everyone, to the July 31st, 2023 Land Use Hearing Officer hearing. We are back from our lunch recess, and I understand that the applicant for variance 23-0564, we have found him, correct?
Yes, he should
Okay.
be online
All
virtually.
right. And so, before we realized this issue, we did take Ms. Brown's testimony already, so I don't think we need to go there. So if we can get the applicant online and proceed with his part of the presentation. Give us your name and address.
Brandon Stevenson, 5216 Point Harbor Lane, Apollo Beach, Florida 33572.
Okay, you can just tell us a little bit about the reason for your variance request.
So the original house was built in 2005. The house that I currently own is built in 2005. And we are trying to build an addition that I've had permitted through Hillsborough County Permit Department for a 20-foot addition on the back of our house. Well, during that process, the architect found that our house was built over the setback, which was supposed to be 5 foot, and it's 4.8 feet. So it's 2.5 inches over on each side of my property. So that's what the variance is for, so I can clear this up and, not have to worry about this moving forward. I felt like it maybe should have been caught way before we bought the house and maybe even grandfathered in, but I don't guess that's the way it worked. So we're here doing the formal request.
All right, let me just ask you a couple questions. So I think you just answered this, but when you bought the house, the setback issue was there, unbeknownst to you, but the house was as is when you bought the house, correct?
Correct. Yes, ma'am.
Okay, and then I think I read in the backup, the addition that you are permitting, you're meeting that 5-foot setback with the addition to the house,
Correct.
right? Okay.
Correct.
That-
Yes, ma'am.
Yeah, that's all I had. I appreciate it. Okay, now we'll go to anyone that would like to speak in support, either in the room or online. Seeing no one, anyone in opposition to this request? All right, no one? Development Services, anything else?
No.
Okay, sir, you have the last word if you'd like it, but you don't have to take it.
I'm good. Thank you so much.
All right, thank you, I appreciate it. So we'll close variance 23-0564. And before we pick back up with the regular agenda, I forgot to ask, is there anyone in the room that plans to testify that was not sworn in this morning? Okay, looks like we're good. All right, then let's proceed with the next case.
Next item is item H10, variance 230602. The applicant is Rafael Rendon. The request is a variance to fence requirement. Staff findings will be provided by Caroline Peddle.
Good afternoon.
Caroline Peddle with Development Services.
Hold that microphone just a little bit closer.
Sorry
Perfect.
about that.
That's okay, there you go.
So this is variance 230602. The applicant requests a fence variance of 2 feet to allow for a proposed 6-foot fence in their front yard zoned ASC1 along Wayne Road. Per code LDC section 60702 C1A, the maximum fence height of 4 feet is permitted in required front yards, except under certain circumstances that do not apply to this case. LDC Section 60702C2, fences in agricultural districts shall be regulated in the same manner as fences in residential districts, except under certain circumstances that do not apply to this case. In my findings, the lot is certified as a legal nonconforming lot per NCL 1704-12 in regards to lot width. With that concludes my report.
All right, thank you so much, I appreciate it. All right, is the applicant here? Good afternoon.
Good afternoon. My name is Lisa Wilson. I have a company called The Permit Tech. My address is 13144 Angler Street, Spring Hill, Florida, 34609. So the applicant had a home there before that burnt down, and he's since rebuilding a much larger, much grander, much nicer home, and decided in the interim of building the home that they wanted to fence the 3 sides and then do a moving fence or a moving gate for the entrance. The fencing that they want at 6 foot in the front will be opaque. It'll be like a black metal fencing. You'll be able to see through it. They just wanted a taller height for better protection and aesthetically pleasing in the front of the home.
So a wrought iron type fence or something?
Correct.
I see. Okay. All right. Does that complete your presentation?
That completes it.
All right. Thank you. If you could please sign in with the clerk's office,
Thank
I
you.
appreciate it. All right. Is there anyone here that would like to speak in support? Either in the room or online? Seeing no one, anyone in opposition to this request? No one. Ms. Marshall, anything else?
No, thank you.
All right, ma'am, you have the last word if you'd like it. Excuse me, ma'am, you have the last word if you'd like it, but you don't have to take it. You're good. All right, thank you. Then with that, we'll close variance 23-0602 and go to our special uses.
This brings us to section I, special uses. The next item is I-1, special use 230350. The applicant is Clayton Brickelmeyer of Hillwarden Henderson. The request is a special use for a school. Staff findings will be provided by Tim Lampkin after presentation by the applicant, followed by Planning Commission staff findings provided by Brett Sferinger.
Thank you. Good afternoon.
Good afternoon. Clayton Brickelmeyer with Hillward Henderson, 101 East Kennedy Boulevard. I'm just going to put this up here since it's so handy. So this is a special use for school in a res district. It's an interesting situation we find ourselves in because the intention is to develop a school on this site, but the vast majority of the site is CG, so school is by right use in that area. What is left is this portion, which is 137 feet from College Avenue, and I don't know how wide, the width of the property, which is zoned RSC6. In my mind, with these special uses for the schools, you know, we look in section 6 and it says, is it on a collector road? College Avenue West is a collector road, and there's no lights. So the lights, I will say, I mean, you'll note, it's pretty heavily conditioned even with, given the scenario here, but, and they include the light provision from section 6. But the point for me is this an appropriate place for a school? I believe it is. Most of it's by right. We comply with all of section 6, and we will comply when we are developing the school with all of the many regulations that are in place. That's really it, I think, unless you have any questions. It is, I recognize it's a little bit odd to be doing this in sort of piecemeal, but.
It is, but I just had one question, and that is, I note in the staff report that there's a proposal to exceed the buffering and screening requirements.
Yeah, we had a little bit of contact. We didn't. The planner did with the folks to the west, and I think it just made sense to do a 15-foot buffer instead of a 10-foot, and I believe that's what's going to be continued down that west side of the property.
So that was my question. Does it just apply to the RSC 6, or is it the entire property?
I think it's the intention to do it. I really don't want to commit to any sort of permanent, because we just aren't there yet. It's not engineered. I've seen plans where it continues down the side. I think that was the intention. But for now, you know, what's in front of us, it's just this section.
Understood. All right, thank you. Appreciate it. If you could please sign in if that completes your presentation. All right, we'll go to Development Services.
Yes,
Good
afternoon. Tim Lampkin. I almost said good morning. All right.
It seems like it, doesn't it?
Yes, somehow. All right. Pursuant to Land Development Code Section 6.11.88, and just for clarity for anyone watching, I will put this on the overhead. So what the applicant put up. So the area of request for this special use is this area here, which is 137.95 feet, and the larger parcel here within the CG and the CI school is allowed by right, subject to the Land Development Code provisions that will be reviewed during site and development. The subject of this special use request in context is here, where you have the crosshatched in the yellow. So which the total acreage of the parcel for the charter school as shown here is 14.43 acres. However, the subject area is only a portion of that, is 1.52 acres, zoned RSC 6. It's located directly south of West College Avenue, and the special use area will not contain any structures. It will contain parking, stormwater area, and landscaping. No waivers are requested of section 6.11.88 or variances. I'm going to go to staff findings. The surrounding area is primarily single-family residential in character to the north across West College Avenue and west of the subject site. Immediately east of the site are commercial uses located at the intersection of West College Avenue and First Street Southwest. Immediately south of the subject area is the remainder of parcel zoned CG and CI, and south of that is a railroad track. Per Land Development Code 611.88.b, the location arrangement of lighting, play fields, etc. shall be such to avoid interference with the use of adjacent residential property. In the subject case, the applicant proposes a condition to ensure compliance. Additionally, as was discussed, the buffer required is a 10-foot landscape buffer with type A screening along the property lines. However, I did convey the neighbor's concerns. There's the neighbor to the immediate west also has this same split zoning, but they're developed entirely with a single-family home, and therefore the buffer would have to be for the proposed use. And due to that concern, instead of the 10-foot buffer with landscape screening type A, the applicant proposed the 15-foot, which is also in the conditions of approval.
So then, would that apply also to the CG property where it's adjacent to that single-family home to the west?
So it would not.
It would not,
No.
okay.
Oh, I'm sorry. Sorry, I was, I think so here is the owner's property.
Right.
And I don't have it. So this portion where the owner's property is, yes, they would be required to have the Land Development Code requirement, which is a 10-foot buffer. The subject area of the request here is technically only required to have a 10-foot type A, but the applicant's proposing the 15-foot buffer right here. They aren't required to have an additional buffer there. However, if the applicant wanted to say yes, they were proposing that would be up for the applicant, but they are not required to have that additional buffer.
That was the point of my question earlier.
That's right.
Okay, go ahead.
A minimum required parking spaces will be required in accordance with Land Development Code, section 6.05.02. Access to the site will be limited to one connection along West College Avenue. As the applicant is not required to go through the special use process for the portions of the parcel zoned commercial, general, and CI, staff requested that the applicant remove all the detail from the PD plan and make the entire College Avenue frontage a potential access area. This request was due to staff's inability to sign off on the acceptability of a potential access arrangement, parking, and drive aisle detail within the special use portion of the site, given the predominant portions of the site fall outside the purview of the special use. Staff finds that Transportation Review Section staff has no objections to the special use, subject to the conditions provided in the report. The Planning Commission has also found the applicant consistent with the Hillsborough County Unincorporated Comprehensive Plan. No objections have been received by other review agencies, and should the application be approved, the site will be subject to site development review requirements, and the conditions set forth will set a framework for site development review, including compliance with section 6.11.88 and 6.03.13, and will be examined at the time of site and construction plan review. Based upon the above findings, staff finds the special use complies with the Land Development Code 6.11.88 schools and recommends approval subject to the recommended conditions. The conditions are all in the report. I can read them out, or
I don't think that's necessary. It's part of the record, but thank you.
it is. And that concludes staff's presentation, unless you had any questions.
No questions at this time, but thank you. We'll go to the Planning Commission.
Good afternoon, Madam Hearing Officer. Bryce Faringer, Planning Commission staff. The subject property is within the Suburban Mixed Use 6 future land use category. It's within the urban service area and is located within the limits of the Ruskin Community Plan and the South Shore Area-Wide Systems Plan. The site has a future land use designation of Suburban Mixed Use 6, which allows for consideration of up to 6 dwelling units per gross acre, and a maximum floor area ratio of 0.5 for light industrial uses. The SMU 6 designation is intended for areas that are urban and suburban in their intensity and density of uses. Typical uses within SMU 6 include residential, suburban scale neighborhood commercial, office uses, research corporate park uses, light industrial multi-purpose and clustered residential and/or mixed-use projects at appropriate locations. SMU 6 surrounds the site to the south and west. Residential 6 and office commercial 20 are located to the north. Residential 12 and public quasi-public are located to the east. Further south are the light industrial and residential 4 future land use designations. The site is surrounded by single-family uses to the north and west. Public institutional, light commercial, and light industrial are located east. Vacant uses are located to the southwest and south. The proposed special use is compatible with the development pattern of the surrounding area and meets the intent of Policy 1.4 of the future land use element. It will provide a neighborhood serving use and is allowable under the SMU 6 future land use category, therefore meeting the intent of Objective 8 and Policy 8.1 of the future land use element as well. The proposed special use will enhance the existing neighborhood by providing a complementary use, thereby meeting the intent of the neighborhood protection policies of Objective 16 and Policies 16.2 and 16.3. The proposal also meets the intent of Objective 17 and Policy 17.1 as the charter school is a residential support use, and the improvements are designed to fit the character of the neighborhood. The subject site meets the intent of the Ruskin Community Plan and the South Shore Area-Wide Systems Plan, as schools, recreational amenities, and public services are identified as goals. The proposed K-12 charter school will further the goals outlined in the community plans. Overall, staff finds that the proposed special use request would allow for development that is consistent with the urban service area and the SMU future land use category. The proposed special use would allow for development that is consistent with the goals, objectives, and policies of the unincorporated Hillsborough County Comprehensive Plan. Based upon the above considerations, Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by the County Development Services Department.
Thank you very much. I appreciate it.
Thank you.
All right, we'll call for anyone that would like to speak in support. Anyone in favor, either in the room or online, that would like to speak? Seeing no one, anyone in opposition to this request? I see a
believe we do
hand.
have some people online.
In opposition? Is that correct? How many people do we have online?
I believe we only have one, and that would be Brant's Rosal.
All right,
Correct.
and in opposition. Okay, and so you're in opposition as well? All right, so there's 15 minutes total, so that would be 7.5 minutes apiece. Does anyone have a preference as to who goes first? All right, the gentleman online, you have the floor. You can go first. You have 7.5 minutes. If you could give us your name and address to start, please.
Yes, my name is Brant Rosal. My mailing address is 2204 8th Street Southwest in Ruskin, but we are the property owners adjoining the applicant to the west. Firstly, the way this is divided seems a little suspicious to me. Our property has that same buffer in the front, the RSC 6 buffer. And that buffer was put there to maintain some kind of residential flavor to the neighborhood. We, at one point, wanted to do some commercial endeavor on the back of our property, which is CG. We've got 5 acres, about 4.2 of it is CG. It's residential use up front, but both of those are zoned CG, but primarily being used for residential use. So we wanted to take and do a commercial endeavor, and I went to the county and he said, no, because you've got that RSC 6 and you may not enter commercial property through residential zoning. So you're prevented from doing that. And that's why it's there. So to assume, oh, this is commercial general, so it's coded, you can do that. Well, that's kind of not the way it is. And I am very concerned because in the staff analysis, they rose some of the objections I had as to traffic. This property is, I don't know, 2/3 of a mile west of Highway 41. At the intersection of this College Avenue and 41, to the east is the Ruskin Elementary School. And if you should happen by that area at opening or closing of school, you'll find the traffic on 41, a 4-lane divided highway, goes back probably a half a mile down 41. College Avenue is the same, and that's a 6-lane divided highway. Traffic is unmanageable when the schools let in and schools let out. Those schools, students come by bus. In this proposed charter school, all students will come by car. College Avenue is a 2-lane road. It cannot support the kind of traffic they're talking about for the school, which was very clearly outlined in the staff analysis, that they had serious concerns on the impact of College Avenue, which wasn't prepared to accept this kind of traffic, how they're going to have the entry to the school. Well, this all seems to get bypassed. If we can just get the special use variance, then we'll worry about that later. Well, the special use kind of protects us. So we're next door. If you're going to take away that buffer, well, then take it away off all College Avenue. So anybody that's got commercial property can enter off College Avenue and do the same thing they're doing. But that's not what the intent was. The intent was to create this residential kind of feel to the community and protect it along College Avenue. And if their only access point is going to be on College Avenue, they've got insurmountable traffic issues. One of which staff pointed out would they would need to take some property by eminent domain, which they can't and won't do. This is not a small undertaking, and to approve this special use is kind of a backdoor way of letting them get their foot in the door to have this school there without the kind of public input and oversight that I think it deserves. So those are my comments, and thank you for hearing me.
Thank you for your testimony. I appreciate it. All right, we'll go to the person in the room who would like to speak. You have 7.5 minutes.
Thank you.
Good afternoon.
My name is Catherine Lawrence. My residence is 406 2nd Street Southwest, Ruskin. My concerns are very similar to the gentleman. My road is at a 90-degree angle. It goes straight out from that property. I worry about through traffic. I worry about, like he said, he really said all of it for me. Ruskin Elementary has the traffic issues, putting a school there where all the parents are driving. My neighbors and I fear that parents will park on the sides of our street, which really is not wide enough for 2 lanes. They will park there and walk to the school to collect their children, making our street an unmanageable throughway. We know that further down that will also happen. It is already happening with people driving through to get around 41 and then come straight down College. I work at a very large school. I know that they are planning for the snaking of parents to pick up. I know it doesn't work like that. Parents will park a ways away and walk and get their kids. I worry about the flooding. We are in a flood zone. They are putting in drainage ditches or drainage retention ponds in the front. Is that going to make, if we have a lot of rain, a hurricane, is that going to flood into our area? I have a waterway that's small behind me that has some tidal ability. Is this construction going to create issues with those of us who live on that going toward a little inlet that goes out into Tampa Bay? I'm here to kind of represent some of my neighbors, and our big concern is going to be the traffic. We didn't realize, some of us didn't realize this was happening until the sign went up for this meeting today. So just like to know what they're going to do, how they're going to handle it. Just having one entrance that they say is going to take care of traffic just off 41 is, to my knowledge, not going to be very manageable. Thank you very much.
Thank you for your time. If you could please sign in with the clerk's office. All right, seeing no one else in opposition that wants to testify, we'll go back to county staff. Is Mr. Ratliff available online?
Yes, I believe he should be available online.
Yes, ma'am.
Good afternoon, Mr. Ratliff. How are you?
Well, thank you.
Good. You heard the testimony in opposition. If you could, and I've read your transportation agency comments, if you could go over the trip generation and site access analysis that's required by the conditions, as well as improvements that the developer is required to do on College Avenue. Sort of summarize that for us, and what are the requirements?
Sure. So the conditions that we've proposed, and again, for the record, James Ratliff, Development Services, Transportation Review Section. So the conditions we've proposed kind of set forth what's going to be required at the site and subdivision stage of the project. And that's traffic study to do a trip generation and site access analysis, which examines the safety and operational efficiency of the proposed project and impacts to adjacent roads and intersections. Specifically, we wanted, the direct project access itself, as well as the intersection of 41 and College, the intersection of College Avenue and First Street Southwest, and then of course that segment of College Avenue between the project, because we do have conceptual concerns. Again, without a study in front of us to review, there we really don't have any information to be able to say one way or another whether this a school of that size or magnitude could work here. So again, did have concerns about it, which is why we put those conditions in there to make sure that we were looking at that, because we want to understand when it comes into site, is this going to create, either cut people on the north side off from access from their home, which would be problematic, or, potentially cause people to queue over into US 41, creating safety and operational issues on that roadway. So that's what the study is going to look at from that standpoint with regard to the traffic analysis. And then I apologize, there was a second aspect to, I think, your question. The improvements.
Improve. College Avenue.
Yeah, so with respect to College Avenue, it's a substandard roadway. And so per our procedures in the County Land Development Code, the applicant's required to improve substandard roadway between their project access and the nearest roadway meeting applicable standards, which in this case would be 41. And so the applicant will have the option of coming in and, to the extent that there's right-of-way available, making those improvements, or they can go through the substandard road process to work through with the county engineer the potential for a design exception to allow some improvements to the roadway, but to something less than the full typical section standard. We did place a condition on it to ensure that regardless of whatever happens through that process, there will be bicycle facilities, which are a key element of collector and arterial roadways, and also very important for getting kids safely to to schools. And so we drafted the condition to make sure that those would be in place despite that process.
Let me follow up with one question, and that is on the condition which requires the trip generation and site access analysis. I was looking for the timing of that, when actually that would occur. And the language says the applicant shall meet with the county staff to determine an acceptable methodology and scope of the analysis before proceeding. Before proceeding with what? At what stage of the review process?
So this would all be happening at the site and construction plan submittal process. So they would have to come in either before they submit for those construction plans, or they could go ahead and submit construction plans and then submit the analysis at the same time. Ultimately, we would not be pushing forward, to give a construction or site plan approval until we were comfortable that the analysis proves out that whatever size school they're proposing meets the requirements of the zoning condition and the methodology that we'll set with them, and ultimately that we're satisfied, that the project can, proceed without those safety and operational impacts.
And then finally, does that analysis also is the time when the queuing plan for the parent pickup and drop off is analyzed?
Correct. Yes, we would be reviewing. Normally when this comes in through, I would say, a special use where the whole the whole site is in, or if it's a PD zoning where they're asking for school approval, we would be reviewing it at that earlier stage. But because we don't have that option here, because the entire site is not within the purview of the special use, we had to defer that to the site construction plan review stage.
All right, thank you for those comments. They were very helpful. I appreciate it. Ms. Marshall, give you an opportunity if you wanted to add anything to the conversation.
Nothing further.
All right, thank you. Then, Mr. Brickemeyer, we're time for rebuttal.
You didn't there. Now it's back on. You actually anticipated most of what I was going to say. There is, as you are aware, and I just pulled up the school on the east side of 41 to see, and I would venture to say that predates the queuing requirements that we are currently living under. I have seen draft site plans, and there's a lot of queuing area, and it will be there. I was going to mention all those conditions that James just went through better than I could. There was a brief mention of drainage. Of course, we will comply with all the site requirements. The only other thing was the gentleman had mentioned that front RSC6 portion. I just wanted to reiterate that in that front RSC6 portion, which is the subject of this application, drainage features and open space and some parking are all that's proposed there. No structures, nothing that would be out of the order, like commercial, that you would think of as commercial. So I think that's it, unless you have any questions.
No, those were my questions.
Thank you.
All right, thank you. Then with that, we'll close special use 23-0350 and go to the next application.
Next application is I-2, Special Use 23-0365. The applicant is VB BTS 2 LLC, care of Matnaya S. John. The request is a special use for a wireless communication facility. Staff findings will be provided by Tim Lampkin after presentation by the applicant, followed by Planning Commission staff findings provided by Bryce Feringer.
Thank you. Good afternoon.
Good afternoon. Mataniah John, 935 Main Street, Suite C4, Safety Harbor, Florida 34695. I have taken an oath. I also have Byron Elkins with T-Mobile here to answer any questions that you may have, and he has taken an oath as well. As you've seen in the staff report, and we'll hear from staff, I come before you today with staff recommendation of approval for a special use to allow 186-foot tall monopine, 199-foot tall monopine style communication tower and facility at folio 060797-3324. The address on the property is 10937 Scully Road, Thanota-Sassa. And all maps I show you today, up will be north, and I do have a PowerPoint presentation if I may be switched over. Understood. So you can see the AR zoning, that's the medium green. The parent parcel is in the middle. You can see that ASC 1 zoning exists to the north, the west, and the east. There's also the Taylor Road right-of-way immediately to the east of the parent parcel, which is a right-of-way that exceeds 50 feet in width, which is operational under your code. And then immediately to the south is a blue area that is a residential planned unit development that has been approved but not constructed. And importantly, the section immediately below where the tower will be is currently programmed to be stormwater facility. This is the future land use designation, just showing the entirety of the area as R1. The purple arrow in both of these maps points to the approximate location of the monopine. A monopine-style communication tower is a tower consisting of a single dull support pole that functions as a trunk. It's painted dull brown. It's larger than your typical monopole, so that way all cabling can be contained inside it. And then it's also pre-engineered to support hurricane-rated branches that are foliated. This is an aerial showing you the area around the parent parcel. The parent parcel itself has a red star on its property appraiser aerial. That's not the location of the tower, but it does identify the parcel itself. The purple identifies the approximate location of the tower. Now, the interesting thing to notice about this is that as you go around, the parent parcel is a pasture, the parcel immediately south is a pasture, you got a parcel to the southeast, it's a pasture, but as you extend out, there's mature canopy. And as you move into the residential areas, most of your residential uses are near or under that mature canopy. This is just a closer aerial, zooming in. And then this is the closest. And this really shows that the existing residential to the north and west are basically under canopy or at canopy, and then to the east you have intervening mature trees. This is sheet Z1A from your plans, or from the plans that are on record. This shows the residential PUD that's immediately south of the tower, and I've highlighted the stormwater area in blue. You'll see a yellow circle, that is the fall zone radius. In the unlikely event of a structural failure, the monopine will not collapse, but rather it'll fold over upon itself at a pre-engineered fail point. This is technology that's been around at least since 2004. I have memory of seeing it at the interstate exit for Kings Highway when Hurricane Charlie came through. Now you'll also see an orange semicircle. And the reason it's a semicircle is this is the 100% tower height separation requirement under your code. And Taylor Road takes and breaks that requirement, so it doesn't exist legally to the east. Now we do exceed the spirit of the code to everything that's constructed, and will meet the spirit of the code to the proposed currently programmed lot. But you can see that part of the residential separation goes on over that stormwater area, and that's where we're requesting a waiver. That is the only relief that I am requesting from your code. Everything else meets or exceeds the requirements of your code. All right, so the nearest house to the north is 4.7 times tower height away. Nearest house that currently exists to the south is 3.5 times tower height away. Your code requires 100% tower height. East, 2.03, west, 3.6. This is just sheet Z2 of your of the plans that are on file. It just shows that the monopine will be equipped for co-location. It will be able to support up to 4 carriers. T-Mobile will be the anchor tenant. So you can see equipment pads in the northeast, the southeast, and the north, or the southwest corner. The southwest corner is where T-Mobile's equipment is currently planned to go. That compound will be enclosed by an opaque fence, which is a request over and above the code that your staff has required out of sensitivity to the PUD to the south, and we're happy to provide it. Additionally, it will be surrounded by the 20-foot type B buffer required under your land development code. This is an aerial of the monopine showing the canopy starting height at 80 feet, extending all the way up to the top. T-Mobile will be located at the top. The height of the monopine is dictated by T-Mobile's RF needs, so there's no extra space up there that's speculative. It's all needed. There are 2 other co-location spaces available on the site. We have mailed off to the other carriers per your code that's in the record. We've also provided a co-location affidavit that will be recorded at site plan. I'm going to run through photo simulations. So the first simulation is showing at Taylor Road and Scully Road looking south, and you can see that the monopine is poking above the tree line on the right-hand side. But you can also see that it's within scale of objects in the view shed, such as that power line that's over on the left-hand side of Taylor Road. You'll also see that vegetation in the area very quickly buffers most of the monopine. This is the clearest view of the monopine. This is at the intersection of Taylor Road and Carter Grove Lane. And you can see at this distance, there's visibility. I don't have a Romulan cloaking device, but you can see that the trees around there are able to provide buffering for the base, depending on where you're at. And then also you have other objects in the right-of-way that are there. Next one is from the Triple T Mobile Home Park. Looking northeast, you cannot, whoops, my apologies. And you can see it between the trees in the middle. But the oak trees are more than tall enough to fully obscure the monopine, depending on where you're standing. And then the last one is from Elberton Road looking east. And you can see that there is some visibility way in the back. Unfortunately, I don't have a pointer. It blends into the height of the tree line. All right, RF package. T-Mobile's targeting improved coverage in the area around the node of Sassa. They're currently trying to serve the area with 7 towers. There's 4 in particular that they're trying to serve with. This is the aerial showing raw coverage in the area. And it's the proposed monopine is the blue dot. The red markers are the existing towers in the area. And basically, green is reliable in building coverage, which is important because that's where people use their phones, especially nowadays with our hard lines being cut. And yellow is reliable in vehicle coverage, but unreliable in building. So essentially, the area around the core of Tenoda Sassa and then areas off to the east and the southwest are lacking raw coverage. What I can't show you on the map is the effect that this has on the towers that are currently trying to serve the area. Cell towers are just like roads, and T-Mobile fights the same capacity challenge, concurrency challenges as the county fights. So by adding this tower to the area, you essentially remove traffic from the neighboring towers and allow them to function better. This just shows the proposed coverage after the monopine is brought online. This shows, this is your 911 call statistics. And I apologize, I'm trying to rush through this since this has been a long day. Let me just go straight down through my housekeeping. I told you, notice was sent out on 6/16/23. That affidavit's on file. I told you about the co-location offer letters. Vertical Bridge has received its FAA approval and HCAA approval. This monopine will be completely dark at night. Your county expert has reviewed the monopine and has determined it to be necessary. I'd also like to bring to your attention that your code considers tree type camouflage and AR zoning to be presumed compatible with the surrounding uses. And then finally, I'd like to bring your attention to the 911 call statistics. In 2018, over 84% of all 911 calls received by the Hillsborough County Sheriff's Office came from wireless numbers. And this just shows that reliable wireless service isn't a luxury, it's a necessity. With that, Vertical Bridge is agreeable to all of staff's proposed conditions of approval and incorporates those into its presentation in chief, as well as the analysis of your expert staff and the analysis that I have provided on file in the project narratives. I am available, Mr. Elkins and I are available for any questions that you may have, and I reserve any remaining time for rebuttal.
Just a quick question about the waiver from the 100% setback, and if in the notice of this hearing, if you heard from that planned development property owner to the south.
This is Matt Tenaya, John, and to my knowledge, I have not.
All right, thank you so much. I appreciate it.
Thank
If
you.
could please sign in. All right, we'll go to Development Services.
Good afternoon again. Tim Lampkin, Development Services. To introduce Special Use 23-0365 for a wireless communication facility. Pursuant to LDC Section 6.11.29, the request is for a special use permit for a proposed 199-foot-high antenna tower with tree-type camouflage that will be located at 10937 Scully Road in Thono, Tosassa, Florida, approximately 1,100 feet south of the intersection of Taylor Road and Scully Road. Staff's findings, the host parcel is approximately 15.39 acres in size. It's split zoned with 1.26 acres zoned ASC1, located on the northern end of the subject site, and the remaining 14.13 acres is zoned agricultural rural. The proposed tower compound is located in the southeast portion of the subject property, as the applicant showed. According to the applicant's narrative, the subject folio is currently developed with an improved pasture and horse farm. The surrounding area is developed with a mixture of agricultural and residential uses. Per section 6.11.29.D.3.B.2, new wireless communication support structures shall be reviewed as a special use when the proposed tower is 100 to 200 feet and located within 250 feet of specified properties zoned ASC1, AS1, RSC, RMC, RDC, and residential plan development. To the south is a planned development that has residential. The subject wireless communication facility exceeds the minimum setback requirements found in LDC section 6.11.29.D.2, which require proposed antenna towers to meet the setbacks for principal structures in the property zoning, except where the facility is located on property adjacent to residential. In that instance, the setback of 100% tower height is required. The property located immediately to the south of the proposed tower is zone PD 06.0085 and allows for up to 22 single-family homes, and the southern setback of the proposed tower adjacent to this residential PD does not meet the 100% requirement. I can actually put this on the screen right here just so you can see. The applicant is proposing a setback of 91 feet and with a 108-foot waiver. Here's an excerpt of the PD site plan, PD 060085. This area here is designated for stormwater pond. That. The staff notes that the nearest residential lot within the PD is approximately 297 feet from the proposed tower, substantially exceeding the 100% setback requirement. According to the applicant's survey, while the proposed tower is located approximately 91 feet from the residential PD, the proposed tower is located approximately 667 feet to the nearest existing residential dwelling. The proposed facility is separated from residentially developed properties in a PD zoned for residential use to the east by Taylor Road, which has a 50-foot right-of-way and therefore is not adjacent to residential development to the east, as the applicant noted. The proposed antenna tower's setbacks are approximately 864 feet to the northern boundary, approximately 544 feet to the western property boundary, approximately 91 feet to the eastern property boundary, and also to the southern property boundary, all of which exceed the minimum principal building setbacks. Additionally, pursuant to Land Development Code 611.29.d.3.b, identifying zoning districts requiring camouflage, the applicant is proposing a camouflage tree type in accordance with the requirement. Other than the waiver of the 100% setback requirement for the southern boundary, the proposed communications facility meets Land Development Code requirements, and the applicant has not sought any other waivers to the regulations contained in LDC Section 6.11.29. Additionally, the applicant has agreed to provide a minimum 6-foot tall opaque fence to visually screen the lower portion of the tower compound, which has been reflected in the proposed conditions of approval. Pursuant to Land Development Section 6.11.29.e, an outside expert has reviewed the support materials submitted by the applicant, and the consultant has indicated in the report that there are no viable tower structures, public structures, or other appropriate support structures in the area that will allow T-Mobile to meet their needs of the network in this area and co-locate. The consultant has also reviewed and analyzed the report and coverage maps and is in agreement with the applicant's findings. Aviation Authority has also reviewed and has approved the height zoning permit. A variance was not required, and that was on June 16th. The applicant has also submitted a letter of intent committing the antenna tower to be shared for co-location. That no transportation impacts have been anticipated by transportation staff. The facility will not have a person there, and very few peak hour trips are expected. Staff has received no objections, and for the reasons above, staff finds it approvable. I can read the conditions. They all are in the report, though.
Yes, not necessary, but thank you so much. I appreciate it. We'll go to the Planning Commission.
Good afternoon, Bryce Faringer, Planning Commission staff. The subject property is located within the Residential 1 future land use category. It is within the rural area and is within the limits of the Thanotosassa Community Plan. The site is designated as Residential 1 on the future land use map, which can consider a maximum density of 1 dwelling unit per gross acre and a maximum intensity of 0.25 FAR. The Res 1 future land use category is intended for areas that are suitable for rural residential uses, compatible with short-term agricultural uses. Typical uses include, but are not limited to, farms, ranches, residential uses, rural-scale neighborhood commercial uses, offices, and multi-purpose projects. Res 1 surrounds the subject site to the west, south, and east. The residential 6 future land use category is located north. The residential 2 future land use category is located further south. The site is surrounded by single-family residential uses to the west, north, and east. Agricultural uses are located directly to the south. The proposed special use is compatible with the development pattern of the surrounding area and meets the intent of Objective 4 of the future land use element. The proposed communication tower will meet the minimum setback requirements found within the Land Development Code. This will ensure that the proposed special use is developed in a manner that is consistent with the development pattern of the surrounding area. Therefore, the proposed tower meets the intent of the Neighborhood Protection Policy direction under Objective 16 and Policies 16.1, 16.2, and 16.3 of the future land use element. The proposed special use meets the intent of Objective 9 and Policy 9.2, as well as Objective 46 and Policies 46.1 and 46.2 of the future land use element. These objectives and policies require all telecommunication towers and facilities to be in areas with compatible land uses and to adhere to all local, state, and federal laws. There are no applicable goals, objectives, or policies within the Notasasa Community Plan that relate to this request. Overall, the proposed special use would allow for a development that is consistent with the goals, objectives, and policies of the unincorporated Hillsborough County Comprehensive Plan, and that is compatible with the existing plan development pattern found within the surrounding area. Based upon the above considerations, Planning Commission staff finds the proposed special use to be consistent with the unincorporated Hillsborough Comprehensive Plan, subject to the conditions provided by the Development Services Department.
Thank you so much.
Thank
I
you.
appreciate it. All right. Is there anyone in the room or online that would like to speak in support? Anyone in favor? Seeing no one. Anyone in opposition to this request?
Yes.
Okay. One person online, or do we have more? One person?
I believe it's only one.
Okay. Go ahead. Give us your name and
Hi.
address to start.
Good afternoon. My name's Karina Cobb. I live on 1112 Serenity Oaks Lane. So there's only one way in and out of our neighborhood, and that's through Serenity Oaks Lane and Taylor Road. The news of this proposed cell tower was such a surprise because we have had zero cell service issues. We have tons of trees on our property. The lot next to us, 5 acres, vacant, full of trees, and it's closer to Taylor Road. We still have zero cell issues. So I was really surprised to hear about this proposal. There's a cell tower that's less than a mile away as the crow flies on 579 and 301. So I'm not understanding the purpose of this. With this application, there's also a setback request, and I asked why. The only conclusion I can come up with is this setback would make it more convenient and less of a nuisance for the applicants whose address is on Schooley Road, not Taylor Road. So I submitted some pictures, but I'm not sure if you received them. It's the first time I've done this. My first picture is actually the picture of our neighborhood entrance, Serenity Oaks Lane and Taylor Road. I think you might have these pictures in your documentation. So if you're looking at that picture, you turn the left side of the picture is where the proposed site will be, which is only maybe 300 to 400 feet from our entrance. The applicants who live on Schooley Road, they're not going to see this 200-foot tower with the 6,500 square foot facility every day, twice a day, like we will when we're coming in and out of our property. I have another picture that I submitted. It's a picture of the applicant's property on Schooley Road. And if you look at their house, they would really have to stretch their necks to look at this tower from the back of their windows. My neighbors living on Taylor Road, right across from this proposed site, they're going to see this 200-foot tower with the 6,500 square foot facility every time they walk out of their house or when they look out their windows. There's also a request for utility access off of Taylor Road. So when repairs and maintenance are needed, the applicants will keep the workers and any of the activity out of their view or going through their property. And they will be so much more detached to this property than we will be. And that's why I'm so opposed to this, as well as several of our neighbors. Seeing this every day, there are no monetary benefits to us, but there are to the applicants. I'd also like to add that my neighbor, who's almost directly across from the proposed cell tower site, he was approved for rezoning back in, I believe, 2021. He did request special access for a driveway on Taylor Road, and he was denied. So how do you approve this special access request but deny him for the same request? So now let's take a look at the compensation for land leases for cell towers. It's remarkable and very, very lucrative. The contracts can be decades long, and there's usually an initial payout of hundreds of thousands of dollars. It's very appealing for property owners, but the rest of the surrounding neighbors in our community, we're the ones that are going to suffer. Why do we have to suffer while they cash in? Especially when there's no need for this. There are several ways this will cause harm in the neighboring properties. First of all, our property values will be affected. According to the National Association for Realtors, they found that 94% of buyers would have less interest in a property located near a cell tower. There's a wireless equity group who boasts being a leader in telecommunications and wireless infrastructure. Research on their website, research shows that over 90% of home buyers would pay less for a property near a cell tower. In fact, HUD even classifies a cell tower as a hazard and a nuisance, requiring appraisers to make adjustments to value due to the effect on marketability. So on their same site, this company offers landowners with cell leases additional opportunities to make more money with their existing leases. So it's not going to stop here. This is just the beginning if you approve this. If my husband and I would have known that a cell tower would be installed at this location, there is no way we would have purchased our home 3 years ago. If we put our home up for sale when this cell tower gets built, potential buyers are going to see, that's the first thing that they're going to see before they even enter our road. And they're going to walk away. They're going to drive right by. And how do I know this? Because that's exactly what I would do. And I would say the majority of you would be doing the same. So I believe my neighbors submitted some letters of concern focusing on the health risks, which is our number one concern. Everyone agrees that there needs to be more research on the effects of cell towers and our health. I want to remind everyone that cell phones became mainstream back in the late 1990s. So that's just over 20 years ago. Wireless companies say there's no long-term effects. But that's what Big Tobacco said about cigarettes, and that's what Monsanto said about Roundup. It took Big Tobacco over 100 years to find out that cigarettes cause cancer, and Monsanto 44 years to find out that Roundup causes cancer. So what's going to happen when the research comes out that 4G and 5G cause cancer? Let's say hypothetically the applicants have a 30-year lease. What does that mean for us? Why even open this up when there's absolutely zero need in our area? So I ask the board to please vote no. If this was going up in your neighborhood, would you be okay with it? Thank you for listening to me.
Let me just ask you real quick. You mentioned photos and you mentioned letters submitted into the record. How did you submit those to the county?
Well, the letters were submitted via, and the photos, email.
Okay, then I don't have it in the backup, but there is a entire online county file for this, so I'm sure if you submitted it to county staff, then it should be as a part of the record. And we
Yes,
will,
and I was there earlier, but I couldn't stay for the meeting, and I would have shown the pictures to, for everyone to view.
yeah,
But
let's verify.
unfortunately-
Ms. Marshall, you can verify that it's a part of the record?
Yes, I did confirm there in the
All right, ma'am.
part of the record.
Just to
file.
close that loop, we do have them, and I'll be able to review them. I appreciate your testimony. Thank you so much.
Thank
All
you.
right, seeing no one else in opposition, we'll go back to county staff for any additional comments.
Nothing further.
All right, then the applicant has 5 minutes for rebuttal. Can you turn on the microphone? There you go. Perfect.
Good evening, good afternoon, Matt Tenaya, John. And as a point of order, I did reserve the remaining time on my.
We'll certainly allow that. And before you start your rebuttal, I apologize, but Ms. Dorman, if you could just, for the record, talk to the person in opposition talked about the testimony about the health effects of towers. And I just would like your input on those sorts of issues relative to land use decisions and the legal aspect of it.
Certainly, Madam Hearing Officer. The Telecommunications Act of 1996 states that local governments cannot deny an application based on environmental effects if the FCC guidelines are followed by the applicant.
All right. So thank you so much. All right, go ahead with your rebuttal.
That's actually where I was going to start. And next I'm going to bring up Byron Elkins with T-Mobile.
Good afternoon.
Please state your name and address for the record.
Good afternoon. I'm Byron Elkins with T-Mobile. Address is 5901 Benjamin Center Drive, Tampa, Florida. And I have been sworn.
Thank you.
All right. Mr. Elkins, there was a mention of a tower located at, well, for starters, are you familiar with the Skeely Road project? It is identified in T-Mobile's records as A2G 2288D.
Yes, I am.
And how are you familiar with it?
I work on the design team for T-Mobile, where we specify a target area that needs improved coverage. We release search rings for companies like Vertical Bridge to fulfill our network gaps. And I've been briefed by our engineering team on this location.
All right. And what's your education and experience?
I am been with T-Mobile now for 25 years, actually starting next month. And prior to that, I have 8 years of DoD training in communication systems.
All right. First things first, does T-Mobile operate its networks within FCC safety and regulatory guidelines?
Yes, extensively. All regulatory requirements are met for each system during the design phase.
All right. And do you operate your network within FCC safety and regulatory guidelines?
Yes, we do.
All right. There was a mention of a tower existing at US 301 and County Road 579, which, I'm sorry, I don't have a pointer, but it's on the north side of Thanota-Sassa from the best that I can tell. I'm showing the RF package that was presented originally, and it is on the screen in front of you. Madam Hearing Officer, we also have an RF package in this presentation that overlays different bands on an aerial to help orient better, but that was not presented to Mr. Monzingo because it was brought up when some of the letters were talking about putting stuff down on the landfill by I-4 and stuff like that. But do you currently have a tower up off of 301?
It appears we have 2 towers along 301. Both are positioned north and northwest of the currently designed location.
Okay, and is that the red dot that is in the approximate center left of the map that I am showing on the screen? The red square?
Yes.
All right. And then the other one, is that the one that's to the far left in the northwest corner of the map?
Yes, it is.
All right. Again, my apologies for not having a pointer. Can either of those towers solve the gap in service that T-Mobile is currently experiencing?
Based on current service usage levels and predictions of the new coverage and enhanced coverage from the models that we use for prediction, no, they cannot reach that area.
And are these towers even able to physically reach that area?
Outdoor coverage only.
I mean indoor coverage, my apologies.
I'm sorry. Yeah, no, our predictions and our data from customer care and our internal systems indicate that the in-building coverage is reliable in Thanota-Sassa.
All right. And as you're saying, in-building coverage, is it reliable or unreliable in Thanota-Sassa?
Unreliable at the moment.
Thank you. All right. Madam Hearing Officer, do you have any questions for Mr. Elkins at this time, or may I wrap up my rebuttal?
No questions.
All right. Thank you so much. You may take a seat. Of course, I joined the county attorney's office and reminded the dais of the Telecom Act of '96. Additionally, there was some speculation as to property value. I respectfully submit that the objector did not lay a foundation to create themselves to be an expert in property value. So that would be lay opinion. To the extent that you feel that you need more information on property value,
That's not lay opinion.
No, ma'am, it's not appropriate for you to comment.
Oh, I'm sorry. Excuse
Thank you.
me.
Anyways, to the extent that you would feel the need to hear more on that, I can continue and get a property appraiser to come in here and analyze this. But I respectfully submit, I mean, there's a number of towers in Hillsborough County. We have an affordable housing crisis, not, a low property value crisis. But if you do request that, that is available. And then just to wrap up on access, the tower is unstaffed. It'd be accessed by 1 trip per carrier per month, so 3 trips per month. And then staff also specifically addressed the condition of access off of Taylor Road by requiring that access to be locked and controlled by Vertical Bridge and its tenants, so that way the landlord cannot use it. And with that, I and Mr. Elkins are available for any questions you may have.
No further information or questions at this time. Thank you so much.
Thank you.
So with that, we'll close special use 23-0365 and go to the next case.
Thank you for your time.
Thank you.
Next item is item I3, special use 23572. The applicant is Drury Development Corporation. The request is a special use for COP SX alcoholic beverage permit with separation waivers. Staff findings will be provided by Camille Crocta after presentation by the applicant.
Good afternoon.
Hello. I'm just trying to pull up a presentation really quick.
No problem. Do you need some help with that? There's someone here that can help.
I have it pulled up, but I don't know how to get it on the screen.
Help is on the way.
Okay. Bryce Pinson with Half Associates on behalf of the client, 1000 North Ashley Drive. And the client is also here for any questions afterwards. So the location is off of East Adamo Drive in a commercial area. The PD 22-1226 is approved for a hotel and restaurant. The surrounding uses are mainly hotels, retail, commercial type uses. The request today is for a 4 COP SX alcoholic beverage permit in association with a hotel motel. The waiver, the distance separation waiver today is for to add another alcoholic beverage permit within 1,000 feet. There's right now only a maximum of 3 approved permits allowed within the code, so this would be adding another one. It's located along a principal arterial and major roadway. There's varying commercial, retail, restaurant type uses in the vicinity, like I stated. And the staff report also stated the proposed wet zoning does not pose significant impacts on the surrounding land uses. And it also states that 4 of the 6 wet zone classifications are on the west side of Falkenberg Road, which is a 115-foot right-of-way, negating the cumulative impacts of the 6 wet zonings. Development Services staff found the proposed alcoholic beverage permit request approvable. And also these are the 6 permits that are right now within 1,000 feet of the hotel, showing you that they're all hotel and restaurant type uses. And that's it. And I'm here if you have any questions.
No questions at this time, but thank you. If you could please sign in. Development Services.
Good afternoon, Camille Crockett, Development Services. As the applicant's presentation stated, they are requesting a distance separation waiver for a 4 COP SX alcoholic beverage permit for beer, wine, and liquor and for the sale and consumption on the permitted premises in connection with the proposed hotel that was recently approved under PD Plan Development 22-1226. It does allow the host use and consideration of proposed wet zoning, and that will comprise a footprint of about approximately 110,967 square feet for the hotel only. Per LDC Section 61111D5, there shall be no more than 3 approved alcoholic beverage uses of the same classification within 1,000 feet of the proposed use, measured from the proposed structure to the existing alcoholic beverage uses. And according to the survey submitted by the applicant, the request does not comply with this requirement. As the applicant stated, there are 6 of the same type within the 1,000 feet. They also spoke to mitigating the impacts of that because the property is located about 115 feet across Falkenberg Road and has no functional relationship to the other approved wet zone permits. So, with the above stated, staff finds the proposed 4 COP-SX alcoholic beverage permit to be approvable with the following condition. The wet zone area shall be limited to the hotel main building structure only. And this concludes staff presentation.
Thank you so much. I appreciate it. All right, we'll go, at this time, we'll ask for anyone who would like to speak in support. Anyone testify in favor? Seeing no one, anyone in opposition to the request? No one. All right, county staff.
Nothing further.
All right, the applicant, anything else? All right, thank you for that. We'll close special use AB 23-0572 and go to the next case.
Next item is item I4, special use 23-0599. The applicant is Main Street Market LLC. The request is a special use 2 APS alcoholic beverage permit with separation waivers. Staff findings will be provided by Jared Folan after presentation by the applicant.
All right, is the applicant here? Yes, ma'am. Go ahead and come forward. Thank you for being patient with us all day.
Good afternoon.
Good afternoon. Give us your name and address, please.
My name is Dia Sorsur, 10802 Main Street, Son of Sassa. I hope I did it right. Florida 33952.
Thank you.
So I just moved here from North Carolina, and I'm trying to open up a business right now, which will be a deli with a convenience store right off of Main Street in Thanassassa. And I had a few issues before with this. Well, when I first got here, I didn't understand that we had to do county and state. So now I'm here with you guys asking to get permitted for a two COP. What is it, 2 COP?
2 APS.
2 APS license, which is going to be packaged beer and wine. No sitting down, drinking, just buy and leave. Pretty much that's it.
Let me just ask you a quick question.
Yes, ma'am.
When you sent out the notices for this hearing,
Yes, ma'am.
did you hear back from anybody?
I didn't hear anything back from anybody except for the county, from the county.
Right, but none of your neighbors or anything?
Yeah, I had a few neighbors stop by. I've been working on the place for this would be close to 3 months now. So I've been in there working on it, working around it, working with the property manager on the building and whatever needed. Once I sent the letters out, I had a couple people in the morning, they would stop by, they would ask me, when am I going to be opening? What am I going to be having?
So nobody objected to it?
No, ma'am, I didn't have any objections to it. And I asked a couple of neighbors around me that had, there's a guy that has a dealership next to me. There was a guy that had a sign place next to me. I asked them, they didn't have any objections. They know a lot of the neighbors. There's a neighborhood across from me. A couple of people that lived in there, they're all ready for me to open up, which is going to be a convenience to them, because a lot of them wouldn't want to drive so far away or anything else like that.
All right, well, perfect, I understand. Thank you
Yes,
very
ma'am.
much for your testimony. If you could please sign in with the clerk's office. All right, we'll go to Development Services. Good afternoon.
Good afternoon. Jared Fallon with Development Services.
This is a request to acquire distance separation waivers for a 2 APS alcoholic beverage permit for the property located at 10802 Main Street, Thanatasasa, Florida. The applicant is proposing to establish a convenience store at this location, which will have a footprint of approximately 1,089 square feet with no outdoor area. The subject property is zoned Commercial General, CG, which allows the proposed use in wet zoning. Approval of this type of permit will allow the sale of beer and wine in sealed containers only for consumption off-site. Per section 6.11.11.d.2 of the Land Development Code, the 2 APS AB permit requires a separation of at least 500 feet from community uses, 50 feet from residential side yards, and 20 feet from residential rear yards. According to the submitted wet survey, the permit does not meet the separation requirements for 2 community uses and the rear yard of a residential property. The applicant is requesting 3 separation waivers: a 6-foot waiver from a residential rear yard for a separation of 14 feet, a 112-foot waiver to a public park for a separation of 388 feet, and a 340-foot waiver to a public library for a separation of 160 feet. Section 6.11.11.e.3 provides for approval of separation waivers where there is, quote, special or unique circumstance the alcoholic beverage use applied for does not have significant impacts on surrounding land uses, and certain circumstances negate the necessity for the specified distance requirements. In regard to the community uses, staff finds that the uses are not directly connected to the proposed wet zoning, as both are across a collector roadway to the south with no crosswalk in the vicinity. Further walking distance from the entrance of the wet zoning to the entrance of the public library is approximately 300 feet and approximately 470 feet to the property line of the public park. As for the residential use to the north, the properties are screened by a 6-foot solid wood fence, and approximately 345 feet separates the entrance to the wet zoning to the front door of the nearest residential dwelling. To further mitigate the potential effects of the wet zoning, the applicant has proposed a condition that the sale of alcoholic beverages on the premises will be limited to Monday through Saturday, 7 a.m. to 10 p.m., and Sunday, 11 a.m. to 10 p.m. Based on these findings, staff concludes that the proposed 2 APS alcoholic beverage permit with separation waivers to be approvable, subject to the conditions. I'm happy to answer any questions.
No questions at this time, but thank you. Is there anyone in the room or online that would like to speak in support? Anyone in favor? All right, seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No.
Sir, you have the last word if you'd like it.
I just want to thank everybody.
Thank you, sir, for coming down. I appreciate it. With that, we will close special use AB 23-0599 and go to our last item, the appeal on today's agenda.
This brings us to Section J, Appeals. Item J1, Appeal 230644. The applicant is Tony Sullivan. The request is an appeal of the administrator's decision in zoning interpretation 230370 concerning the proposed use of property located at 401 Mahogany Drive in Sefner and identified as tax folio 66883.2256. The zoning interpretation decision was dated May 31st, 2023. The subject appeal was submitted on June 16th, 2023, and therefore was timely filed pursuant to LDC Section 100501C1. Brian Grady is available for questions regarding the zoning interpretation decision.
All right, before we start, I just want to, Ms. Dorman, I just want to verify what the legal standard is for this review of the appeal. As I read the code section on 10.05.01 regarding appeals from the administrator to the land use hearing officer. Section F says upon the finding of error in the administrative decision. So that's the standard. It's not my opinion of the particular interpretation. It's rather, did the zoning administrator err in that decision in terms of what they had to review? Is that correct?
Yes, Madam Hearing Officer.
Okay. Nothing further to add?
No.
All right. Thank you so much. Then in terms of the format, Ms. Marshall, how is the format for this appeal hearing? And is the appellant here? Is the applicant here? Before we even begin.
Actually, I don't see them in attendance.
All right. It seems to be a
Doesn't
trend
look
today.
like they're online.
Is there anyone online regarding this appeal case?
does not seem that anyone's online.
No one?
No one, ma'am.
Okay, thank you for that clarification. Well, then I would suggest we continue this then to the next hearing, because getting here, in that it's the last case, I don't think that time is we have any more to waste. So what would be that next hearing date?
Double checking, because I think the notice is a little bit different.
Yeah, and Carmen, if you could help us with that issue of what the next date would be and if renotice would be required.
Actually, don't appeals have to be heard within 50 days, Colleen? These kind of appeals? These are different.
I think they have to, let me double check. I think they have to be scheduled within 50 days.
Susan, do you want me to call real quick and see if we can get them virtual?
If you can, I really don't want to take much time to do this. I think it's very unusual given the nature of this that they are not here.
Okay.
You could, but in the interest of fairness, yes, give them a call and see the situation while the staff is looking at the time to be heard issue. Ma'am, in the audience, are you here for this appeal? No. Okay. Just an interested viewer. Good for you. Did you receive anything from anyone on this? No PowerPoint, nothing. Yeah, I have a feeling they don't realize it's today.
Code doesn't give us a lot of direction, I don't think.
So the Land Development Code 1005 in appeals, it requires the administrator to set the matter for hearing within 50 days of the date of the notice of appeal. And then it allows, this is the period, may be extended by agreement of the administrator, the party appealing the decision, and any intervener. But we don't, it doesn't provide any further
All right.
guidance. And
Okay, Carmen, were you able to reach anyone from
No,
that side?
I left a voicemail message.
Okay. Then, would the August hearing be enough time if, presumably, once it's scheduled, you've done your part by the code, and then presumably they would also agree to extend it?
They don't notice fast, so that's a Brian question.
Oh, there's no notice. Is that what you're saying? There's no notice for this?
Correct.
That would make
Yeah.
sense, right?
So,
Okay. Then would the August date be appropriate?
yes.
All
yes.
right, and what is that specific date?
August 28th,
28th?
yes.
Okay, thank you. Then I think it's appropriate then, given the appellant is not in the hearing and we tried to contact them and only received voicemail, that we'll continue Appeal 23-0644 to the August 28th Land Use Hearing Officer hearing. Any further comments, Mr. Grady? Anybody?
Nothing, no further
All right,
comments.
thank you. Then with that, we'll adjourn the Land Use Hearing Officer hearing for the day. Thank you all for your time, patience, and testimony.